Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! My God!
Sing, sing, we're all insane. The fireman's blind, the police are lame. A black padded jacket and a framed up dame cracking out the tail light. Cops are looking for fame. Clap hands, clap hands, clap hands. Said hide, hide, don't you open the door. Son of a bitch is never coming back here no more. Bud Light in the bar and a Jeep on the street. We can always find a scapegoat here to take all the heat. Clap hands, clap hands. Scream, scream, 100 bad dreams. Everybody's butt dialing in their bed and jeans. A missing shoe and a cop's misplaced hat. And nobody's sure where Mr. Nevercracker at. Said hide, hide, don't you open the door. Son of a bitch is never coming back here no more. Bud Light in the bar and a Jeep on the street. We can always find a scapegoat here to take all the heat. Clap hands, clap hands, clap hands. Scream, scream, 100 bad dreams. Everybody's butt dialing in their bed and jeans. A missing shoe and a cop's misplaced hat. And nobody's sure where Mr. Nevercracker at.
Hey, good morning, good afternoon, good evening, good night, everybody. Whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, whatever you're doing and wherever you're doing and however many times you're going to do it, etc. and all that stuff. I don't care. I'm just glad you're doing it here with me on this little old channel we call Legal Vices. Today, we are starting day 32 of the Karen Reed murder trial. Not only is this day 32 of the Karen Reed murder trial, this is day 2 of jury deliberations. They got the case yesterday late morning, and they worked all the way through lunch and up till 4 p.m. and they told the judge they wanted to go home for the evening. I don't know what to speculate on that, but generally the general rule of thumb is the longer it takes a jury to come back with a verdict, the more likely they are to return with a guilty verdict. Now that's just a rule of thumb. It's just statistically seems to be that way. Not saying that's the case here. They could be trying to persuade one of the holdouts or a few of the holdouts. They could just be going over the evidence very, very carefully. The question is, when will we get a verdict? At this point, I would be surprised if it went beyond today, because the issues really aren't that difficult. Did she kill John O'Keefe? That's the basic question. If it's no, okay, fine. That leads us down to not guilty on pretty much all. I think that takes care of all of the charges. Is she responsible for his death? That takes care of all the charges. And if you say no, let's go home. If you say yes, then they've got to start at the top with second-degree murder and work their way down the lesser included offenses until they find something that might fit. So there we go. That's where we are. We're waiting for court to start here. They're supposed to fire up their grill in about 6 minutes and 38 seconds. While we're waiting for that, just a warm, super welcome and thanks to Ozzy Overlord for sending his people on over here. Ozzy Overlord and followers and his minions, welcome. We've currently got 500 people. 500 people here already waiting for day 32 of the trial and day 2 of jury verdict watch. And what we're going to do is once Judge Bev gets done with her initial little spiel and sends them off to the jury room to deliberate, I want to go back through the closing arguments and sort of dissect them a little bit closer. We just kind of watched them without pausing yesterday. Now I want to pause and comment as we go along. And I plan to be live here for probably 3 hours. My feeling, again, my feeling was they might come back yesterday, so that that tells you what it tells you the reliability scale of my feelings. My feeling was they'd come back yesterday, but now I think because they waited overnight, they haven't asked any questions of the judge. They haven't asked for any clarifications or whatnot. I'm thinking that they may have they may come back with a verdict within the first 3 hours today. Again, it's just a gut feeling. So we'll do this for at least 3 hours, and then I'll go to sleep and again task someone who is Flux is usually my go-to girl for waking me up when the jury comes back, if she's willing to accept that assignment yet again. Right. Where have we got here? We have 5 minutes. We're waiting here for 5 minutes. And once I need to get an exact time how long we've been waiting for the jury. And Law and Crime usually does a good job with that. When they're on their verdict watch, they'll post how long the jury has been out. So when they do that, we'll put up the like and subscribe poll for today, which again is going to be how long will it take them to come back with the verdict. I think overwhelmingly we were damn near 90%. I think we were 84% yesterday. You guys said not guilty. 5%, somewhere around 5% said guilty, and the rest said hung jury. So I think we all know where we sit with that. Now the big question. Now the big question is just how long is it going to take? How long will it take for the jury to come back with a verdict? And that'll be our question. In the meantime, while we're waiting, what's on your guys' mind? What did you think? What did you guys think about the closing arguments? They both went, well, I was going to say they both went an hour, but we know that wasn't true. Jackson went 1 hour. Lolly, he went over an hour until the judge told him to shut the F up. And can I please have one more sentence? He said, one more sentence, Lolly. So there you go. Right. The tension. Oh yeah, that reminds me. We can do this. We got some business to take care of. Nancy Joe M started us off with a big $20 super chat. That gets you a bell ring. Nancy Joe M, if the jury comes back with a not guilty verdict early today, I think they didn't want to give a not guilty verdict with the McAlberts in the gallery. Just a thought. I'm thinking the McAlberts are going to be back. They'll have all the McCabe's, all the Alberts, everybody that was there yesterday. I'm pretty sure will come back today. I don't know. They'll be lurking somewhere in the wings. I mean, if they come back early, I would say they deliberated fairly and honestly, and maybe they got to the end of the day and they said, okay, it's going to take us a little bit longer to fill out the jury forms, to get them approved, to go back into court, to assemble everybody, and then to go through the process. So why don't we just call it a night, and then we'll come back tomorrow and finish up the formalities. That's one possibility. Or they could be completely fractured and splintered, and it could take another day or two for them to come back with some sort of a compromise verdict. I don't know. We'll just have to see. But I don't think really the McAlbert's bothering them. They're going to be underfoot. I don't know. What do I know? Chris Mullen became a YouTube member. Chris, welcome to the Clean and Sober Crew, the newest member of the membership people. The chat is the Vice Squad. I don't know what we call the members. Like I said, we call Legal Vices member, but that's just like really weird. So Angie Hammond, I think Bev made them think coming back in a few hours on the same day wouldn't be, quote, good. Well, again, it took her an hour to read through the jury instructions. So, I mean, you figure at least an hour, hour and a half, maybe even 2 hours of the jury deliberation time went into going over those again. Then you got to figure some arguments. So I think you're on to something there. I think that's a possibility. I mean, it's never good just to come right back, because then it makes you look like you didn't take your job seriously. After 9 months of trial, the O.J. Simpson jury came back in 2.5 hours. So, and that's never sat well with a lot of people. So who knows? Nick Starro with the sexy $50 money things. Thank you so much, Nick. We wouldn't underestimate the stupidity of a closed off community where everyone is related. Sorry, I stopped reading there. I was like, where everyone is related, comma, or friends with a Canton cop. Sorry, closed off community where everyone is related to or friends with a Canton cop. Yeah, it does seem to be a fairly cop heavy neighborhood, and I know what that's like because I grew up in a very cop heavy neighborhood. Literally this entire street, well, 1, 2, 3 streets I lived on. There's like this little area of 3 streets. Virtually every house on those 3 streets was worked for the same road construction company my dad worked for. They worked for the university, or they were cops. And sometimes you got the twofer. You got the university. There was a few university cops too. And everybody knows everybody. Everybody's up in each other's business. And that's why I think it's a little extra suspicious that the cops can't even be bothered to go out and see what's going on with the dead body on their front lawn. So, yeah. Nicola Maxwell, all the way from sunny, warm Scotland. How are you, Nicola? It's good to see you here. Member for 5 months. Thank you so much. The JL Agam Ort Jeff August Vice Squad, right? Thanks for making me read that. Shame on you. Ozzy, dang it, Nicola, love you. Ozzy Wombat gifted 5 Legal Vices memberships. Ooh, Nancy Joe M was going to be the Vice Racks for the day with that 20, but these 5 Legal Vices memberships come to 25, so that makes Ozzy Wombat the Vice Racks of the day so far. We'll post that up when the little show gets on the road here, and just so we don't miss the beginning of the show getting on the road, let's bring it up here and smallen it. There we go. And boom, done. Right. The universe has set itself right. And Mathis Greaves, OJ jury admitted verdict was payback for Rodney King. Well, some of them did. Some of them heavily suggested it. Maybe not all 12 of them, and that was more the outside theory, and it's not a bad theory. Especially since like I said, some of them felt that way. Clearly, you are the Law Racks. We members are your paratregals. Oh, okay, Dara, that's cute. Paratregals. Or for the women, you're the paratree gals. You're the paratree gals. Anyway, yeah, you know what I mean. Tiffany. It's Tiffany, not Tiffany. I apologize. Tiffany became a YouTube member of the Clean and Sober Crew. Thank you so much for the support. God, we've got 950 people here. Wow, when the hell did that happen? That's like way cool. Thanks, 952 people, but we've only got 337 likes. That's like 2/3 of you. 600 of you haven't done your job. Get down there and smash that like button. Just get it out of the way now. We're not doing anything. We're just shooting the breeze here until the court gets underway with Judge Bev. Then we're going to go back through the closing arguments. So just while we're sitting here, not doing a whole lot of anything, smash that like button. We should be up to 951 at least right now. So get down there and do that. And while you're down there, while you're tickling the little buttons down there, while you're flicking the buttons down there, think about hitting that subscribe button as well, because we're inching our way to 78,000 subscribers. We're off in the weeds right now a little bit. We're at 77,168 subscribers, which means we're 32 subscribers away from no do math. We're 60 whatever. I can't do math. 30. I'm tired already. 70. That's 30. We're 32 away. We're 32 away from 77,200. It should not be that difficult to add 32 to 168. God, that was embarrassing. All right. Lawyer math. That was an extreme example of some pretty extreme lawyer math disability there. All right. Anyway, thank you very much for the few that have just subscribed. Keep it going. Why not? Let's get us up to. We could probably get up to 78,000 if like a billion people showed up. Anyway, sorry, enough of that. That's not what we're here to talk about. Well, that'll just happen. That'll happen when it happens. You just take care of the like, subscribe, do all the YouTube stuff. Right. All right. Now, yeah. See, this is what I'm worried about. We could start reviewing yesterday's closing arguments right now, but we did that yesterday. We started to watch the cross-examination of the last witness, Dr. Renshaw, and as soon as we did that, court started, and then we sat here and stared at each other for an hour watching Twitter while the news people on Twitter were talking about one of the jurors being ejected. So. Oh, hey, well, I'm glad you're okay, Gamer Ducko. I seriously hope that's like I seriously hope Gamer Ducko's a bot, because that'd be the nicest bot ever. Oh, heavens. Blue Vara with a $6 super chat, with $5 super chat. I had an aunt as the lunch lady, another aunt as the school nurse, and an uncle as a cop in my small town. Yeah, well, I get that. My small town was my 8th grade English teacher, my Spanish teacher that I had for one semester, and my photography teacher. They all worked for my dad during the summer to make money. Everybody, the principal went to school with my dad. The vice principal went to school with my dad. Everybody went to school with everybody else. Everybody your parents' age went to school with each other. Everybody our age went to school with each other. So you literally couldn't get away with anything. Small towns are fun yet awkward at times. Chaos coordinator member for 20 months. This trial contains so much shit that even an army of dung beetles won't be able to roll up that huge turd ball. The hell is that? Even an inch. Thank you so much for being a supporter for 12 months. And Nick's dropping 50 more sexy Swedish dollar thingies. I know they're grown. It's going to be an interesting day when you look out the kitchen window and you see a cat chase a deer. I hope Mr. Jingles wins. Deer stew is great. Go get him, little kitty. Go get him. What happened with Turtle Boy? No idea. See, for those of you that are like wondering about Turtle Boy and all that, I don't really follow the extraneous stuff. I don't really follow the stuff that's out on the peripherals, the backstory, the what happened at the pre-trials. I focus generally on what the jury sees, because in the end, that's really all that matters. What has the jury seen? What evidence has been submitted and presented to court? All the cool little backstory pieces of information that we hear and we see on the news, that means nothing when it gets to trial. So that's kind of what I try to focus on. But I know there was a little episode a couple of days ago, and Jen McCabe's sister and her wonderful husband, they apparently got charged with assault. So, don't lay hands on people. Don't touch people. Keep your damn hands to yourself. Everybody. Somebody's being a dick to you. Someone's being an instigator. You walk away. Don't escalate. It solves a lot of life's problems. just saying. That's not even legal advice. That's just common sense, normal human being stuff. The great thing about small towns is that everyone knows one another. The bad thing about small towns is everyone knows one another. Exactly. We're late, people here. We're 10 minutes late. We'll give them 2 more minutes. If the court hasn't started in 2 minutes, then we'll start with our review of the closing arguments. And when court finally decides to happen, we'll cut back to the court. How does that sound, everybody? And once we find out exactly how long we've been going with the jury deliberations so far, we can set up our like and subscribe poll, which will be, how long do you think it's going to take total time for the jury to come back with a verdict? I thought they'd come back yesterday. A little bit of me did. I'm thinking within the next 3 hours. Oh no, a whole 10 minutes late. Well, it's been 10 minutes. I've had to think of stuff to talk about. Jules thinks 3 p.m. Next case, the McAlberts on trial for killing the jury. Oh no. But for me personally, for those of you, the 1,059 people that are watching this, the next trial, the rest of this week is going to be hopefully relaxed. Hopefully we'll be relaxed next week. But this week. But next week is going to be even more relaxed. That's the 1 week I've got just to chill. We've got something interesting planned for Monday. Tuesday, I'm likely going to have to miss Tuesday. We'll get back to our retro trial on Thursday of next week, and then we've got Wednesday and Friday to do something. But what we're going to be doing is a run up to the Alec Baldwin trial, because starting on Monday, July 8th, we will be covering gavel to gavel the Alec Baldwin trial. That's finally here after damn near 3 years. Oh, you thought next Monday was canceled? Was it? Did something happen with the Alec Baldwin trial that I'm unaware of today? Marta C, can you do a poll for what people think in a chat, and they think he's guilty or not guilty or factually innocent? Well, that's interesting. Yeah, we can do that while we wait. That's an interesting way of putting it. Let's just do that. Like, subscribe. Did I hear? Burning Sensations ironically asks about, did I hear anything about the lithium fire that's new? Yeah, there was a lithium battery plant that burned down in Seoul on Monday. 20 workers died. No, there's nothing new to report that I've seen on that. Like, subscribe, vote. Karen Reed is guilty. Karen Reed is not guilty. Karen Reed is factually innocent, but we'll put in quotes, not guilty. Now we also have to add the other one is, factually innocent. How do we want to word this? Guilty, not guilty. Factually innocent, but guilty. Let's do that. But guilty and factually guilty, but factually guilty, but not guilty. All right, so we've got, she's going to be found guilty. You think she's guilty. You think she's not guilty. You think she's factually innocent, but they'll find her guilty anyway. Or she's factually guilty, but they will find her not guilty. And it looks like the court is coming into session. There's been a little motion. Yeah, this like and subscribe poll requires a little bit of thinking.
Yay. All persons having business before law or Beverly County, Justice of the Norfolk Superior Court before the county of Norfolk. Give your attendance, you shall be heard. I say the Commonwealth of Massachusetts. Court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed.
Law and crime, you want
Good
to
morning, counsel. Good morning, Ms. Reed.
give us some video?
Good morning, jurors. I have to ask you all, including the alternates, those 3 questions. Were you all able to follow the instructions and
There we
refrain from
go.
discussing this case with anyone since we left the courtroom yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? Everyone said no or shook their hands. All right, with that, we'll send you back out to deliberate. Thank you.
Well, that was exciting. Woo! Yeehaw. Don't stare down the jury, bro. They don't like that. Hey, thank you, everybody. You got us over 600 likes. That's an amazing number. That's kind of the number that YouTube seems to like to trigger the serious algorithm deal. So, but keep it coming, and that'll give the more likes. Say, hey, there's something more exciting happening. All right, Jeff,
All right,
talk to us.
so counsel, I don't want the jury to have to wait for us for anything today. So you're to stay in the building until 10. I need you back here for the afternoon, no later than 3:30, and you'll be free to leave during the day as long as you can definitely be in here, in your seats, ready to go on 5 minutes notice. Okay? So we'll see you then.
All rise for the court, please.
That's a tight time frame. Usually the courts will give 30 minutes or an hour for them to assemble and to get the news people and the cameras ready. She's like 5 minutes. You can go anywhere as long as you're 5 minutes away from your seat. All right, so the verdict clock has us at 2 hours and 57 minutes. All right, so we'll finish this like and subscribe poll here right now. We'll put up the one that I want to put up, and then we will go and begin our review of the closing arguments. All right, so let's minimize this. Let's minimize it. It's gone down there. We can see this is one of our last shots we will ever see of the ceiling fan, which we here on Legal Vices have named Ceiling Dion. Good morning, Ceiling Dion. Good to see you. I'll miss you when you're gone. All right, how did our vote turn out? Karen Reed is 2% of you say guilty. Out of 1,221 people, we've got almost 500 votes. And now the guilty is down to 1. Now it's fluctuating between 1 and 2%. Say guilty. 86% say not guilty across the board. Did not cause the death of John O'Keefe. 9% of you say that she's factually innocent, but they'll find her guilty anyway. And 4% of you believe she's factually guilty, but they will come back with a not guilty verdict. Oh, I said no guilty. Great. All right, now we're going to end that one and put up our next poll, which will stick with us until we see who's right. Ooh, I almost super chatted myself. We don't want to do that. Start a poll. No, that's not what I want to do. Like, subscribe, and vote. How long will it take? Should I? I'm going to do host long. Let's do that because that's funny. Host long to reach a verdict. I'm clever that way. Let's see. We're at exactly 3 hours right now. It looks like 2 hours, 59 minutes, and 17 seconds. So let's do 3 to 5 hours total. 5 to 7 hours. And 7 to 10 hours. 7 to 10 hours. And more than 10 hours. All right. That's our new poll here. How host long to reach a verdict? Because I'm funny. 3 to 5 hours, 5 to 7 hours, 7 to 10 hours, and more than 10 hours. Me, I think it's probably going to be in the 5 to 7 hour range. I think it's going to be 5 to 6 hours. They'll come back with a verdict. But so far, 60% of you say 3 to 5 hours. But all right, let's we'll check back in a while and see what that looks like. I'm going to keep an eye on the courtroom camera here to see what's happening. But in the meantime, we're going to go back and we are going to start our review of yesterday's closing arguments. We'll see how far we can get. So let's bring up that screen. Where are you? Share screen. They're both on the ceiling fan. What do you want me to do? I don't know what to do. All right, I have to look at them. It's one of the big ceiling fan. There we go. Right. This is yesterday. I better put up a little, once we start, I'll put up a little banner saying rewatching, verdict watch, rewatching yesterday's closing argument. All right, we're going to start. See, I thought this was really interesting to begin with too, because normally what you will see, because I mean, wherever you are, the prosecution always speaks last. They have the burden of proof, so they get to speak last. Usually you'll see the prosecution give their closing argument, then the defense will give their closing argument, and then the prosecution will give their rebuttal, and they'll get the last word. Now, what happened yesterday was the defense gave their entire statement, and the prosecution gave their entire statement. I don't know if that's the official way they do it there in Massachusetts, where it's just all the defense, then all the prosecution, or if Lally made the strategic choice to not make an initial closing argument and to save his entire hour for what was essentially a rebuttal, which if he had that option, I think it was the right option, because he would get up and give his closing arguments. He would give all of his fancy schmancy nonsense anecdotal things, and then the defense would get up and crush him, and then he would have a few minutes to try to salvage his case. So if it was a strategic option and not something that was required, I think he made the right strategic choice as a prosecutor, to just let the defense have their say, and then you just pretty much ignore what they said and lay out your case. But all right, Tammy Fayette, who's been a member for 8 months, says, hello, Jeff. It's my birthday today. Hi, chat, free Karen Reed. Oh, Tammy Fayette, happy birthday to you. This is a dry week for me, so I have no birthday shot, but I would be happy to take a swaller of lime, of sugar-free lime Pepsi Zero. Cheers to you, Tammy Fayette, a longtime, amazing, wonderful supporter of the channel. Happy birthday. And we have any other things to mention? Unhung Hero, how long do you think it'll take to get a verdict? That's a very good question. That's the one we're asking to you. And like I said, I think 5 to 7 hours. If I had to pinpoint it, I would say 5 to 6 hours. So let's see how this works out. All right, we've got yesterday's stuff all queued up. Let's go to this view here. All right, people, and we're going to stop this. We'll pause it and comment as we go along. It's what I wanted to do yesterday, but hey, we were watching it live. All right. Okay, we can fast forward through the fan.
Draw near, give your attendance, you shall be heard.
Times I start in the morning by saying
We don't have
appreciate
closed
your
captions
patience. So
available.
today is one of those days. Again, we appreciate your patience. You may notice that one of your fellow jurors is not sitting with us today.
Yes, we lost a juror.
I can assure you that that is because of an issue that is just personal to that juror and has nothing to do with any concern of any of you. So please disregard that. Okay? I do have to.
This is so weird, and we've got 1,247 people here, so I'm going to throw this question out. As of yesterday, I'm unable to have, this is on Chrome, not on Chrome. This is on Edge. On Edge, on the Edge browser, I'm unable to have two videos playing simultaneously. I'm unable to have two YouTube videos playing simultaneously. The fuck was that? And I have no idea why. It's a setting I haven't had. If it's a setting, I haven't had time to look at it. But as of yesterday, I can't have two windows playing at the same time. It's weird. So, all right.
To ask you those 3 questions, were you able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes and nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday?
No, we don't need to hear for that.
I've tried a lot of cases in this courtroom. The thing I liked least about the trial was just before I stood up to give my closing argument, the judge would say, jurors, remember, closing arguments are not evidence. We've all known.
All right, here we go.
Look the other way. Look the other way. 4 words that sum up the Commonwealth's entire case. 4 words that sum up the hopes of those who have tried to deceive you. Conflicts of interest? Doesn't matter. Just look the other way. Magic hairs, magic glass. Look the other way. Late night calls and Google searches, falsified affidavits, inverted videos, and butt dials galore. Just look the other way.
Now, yesterday when we got to this point, I must admit I was a little bit nervous. It almost sounds like he's reading slam poetry or something. It doesn't seem like a natural conversation. It doesn't seem like a natural storytelling. It doesn't seem like a natural plea for justice. It's clearly scripted. He's clearly reading the script and he's giving it almost a poetic cadence. And I thought the jury might see this as being insincere and just going through the motions. So I gave him some points off for the initial part.
That's what they want. That's what they're counting on. But the uncontrovertible fact is you have been lied to in this courtroom. And your job is to make sure you don't ever, ever look the other way. Your singular duty is to stare down the evidence and do it unflinchingly and do it unwaveringly. You see, you're the only thing standing between Karen Reed and the tyranny of injustice. It's a job you didn't ask for, probably a job you didn't want. But it's the greatest responsibility we have as citizens here in America. Lest the government stop answering to us and we start answering to the government. And lo be
Sort of, taking government down a notch. That's always a good thing. No, nobody likes government. Nobody's real thrilled about cops either.
Any one of us, anyone.
When I should know, because we've got almost 1,200 people here. Those of you that don't know, I have 2 English bulldogs, both of which are snoring right here on the floor. When we get to $100 in super chats and whatnot, we unlock the emotional support potato pig dog cam thing here. So it's not any snoring, grunting, whatever. It's not me. It's these 2 English bulldogs on the floor behind me. So I'll just apologize for the snoring sound effects here for a while. Sorry.
Us who might find ourselves in the crosshairs of a Michael Proctor. Preparing for today, I was reminded of a quote. It's a quote about the truth, and I want to share it with you. It is of great importance to set a resolution never to tell an untruth. There is no vice so mean, so pitiful, so contemptible, and those who permit themselves to tell a lie once find it much easier to do it a second time and a third. This falsehood of the tongue leads to that of the heart, and in time, it depraves all its good dispositions. What does that mean? It means that it's been observed that to tell an untruth, to exaggerate, to make a false claim, it's a cancer. One lie begets another, and it's a malignancy that grows over time. And that, folks, is how a cover-up is born.
And it's also how you discredit and ignore witnesses who you don't find credible, who you believe have lied, because it's almost a cliche in the law. You know, dishonest in one thing, dishonest in everything. If you catch a witness lying to you about one thing, you can disregard everything that witness says as a lie, because they said something you can't trust. So how can you trust anything else they've said? And that's what he's instilling here in the jurors' minds right now. You have witnesses who you know they lied to you. You know they lied to you about one or more things. And for that, you don't know they've lied once, they probably lied twice, 3 times, 4 times. And so you can just forget what they say and focus on the evidence, on the scientific evidence, the empirical evidence. And this is where I started to feel a little bit better. He still has a couple more quotes to get out of his system, but this is where he kind of started to get into a more natural flow, I thought.
That's how a Massachusetts state trooper says in whispered tones to his friends when he thought no one was looking or listening, how he would make a case, how he would make it cut and dry, no matter the truth. How he would make.
Oh, hang on. The judge is back already. What is this all about? Hang on. What's this noise? That's
in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes,
No objection.
that's fine, Your Honor.
Okay. Thank you.
all right. I'm going to back up a little bit to see what that was all about. We missed the beginning part.
We're back in session. You may be seated.
Judge, we're back on the record on 22-117. I believe we have a question from the jury.
Yes, it's simply, good morning. The jury is kindly requesting to conclude deliberations in time to board the bus at 4 p.m. A juror has a long existing scheduling conflict. So I'm just going to simply say yes and send it back.
Yes,
No objection.
that's fine, Your Honor.
Okay. Thank you.
Well, that was exciting and thrilling, wasn't it?
All right, can we mark this, please?
Triple P for identification.
Thank you. Do you want the envelope too? All right, thank you. We will send it back in with you, Officer Delano.
Good work, Officer Delano. Oh, the camera has to watch him walk out. Yeah.
Thank you. All right, all set?
All rise, please.
All right. And then the judge wanders off. That was terribly exciting, wasn't it? Now we can actually glean something from that, and I see a bunch of you mentioning it in chat already. That kind of has the implication that they're not close to reaching a verdict yet. If it's 9:30 in the morning and they're worried about catching a bus at 4, that's a good indication that they're not on the verge of getting a decision. So, all right, we could be here for a while. That wasn't what I expected. And as long as we're here, Jacob's Proud Madre, how are you doing? Jacob's Proud Madre, one of the OG original subscribers to the membership. Thank you so much for being here and for being a member of the Clean and Sober crew for 21 months. And I love you more every day. Well, Jacob's Proud Madre, you are an amazing woman yourself. You're a fantastic supporter. Thank you so very much for being here. And Katie, you've been a member for 1 month of the Clean and Sober crew. Thank you so much. Lolly P's sitting down. Okay. Thank you for that. Can't argue with you. Chloe Albert's Revenge. Rest in peace on the farm in Vermont. No McCabe people staring down the court today. Well, he was there. He was staring him down a little bit. So yeah, thank you so much for the $2 there. The McCabe people were staring him down. All right, let's get back to our viewing of the defense closing arguments.
Sure to put, quote, serious charges on the girl. In other words, pin it on the girl. You may ask yourself, how does this happen? How could this happen? It's 2024. Surely people aren't going to come to this courtroom, this hall of justice, and lie to us, just give us false information. They wouldn't do that. They wouldn't try to cover up the truth. The Alberts, the McCabe's, Higgins, Lank, Michael Proctor, Yuri Buchanan, Brian Tully. You don't have to wonder if they would lie to support their narrative. You need only wonder how many times they did lie.
Ouch.
Over and over and over. They and others were caught deceiving you. Big things, small things. It didn't really matter. They feared nothing. They'll look you in the eye and deny phone calls. They'll deny secret meetings. They'll claim that calls are butt dials and butt dials are answered. They'll show you a video and tell you left is right and right is left.
I thought that was a brilliant line. I thought that was honestly a brilliant line, because it's literally what they're doing in the middle of giving all of these examples of lies and whatnot. You know, small ones, big ones. He referenced something that they made a huge deal about. They were literally saying that left is right and right is left. I thought that was a primo line. It caught my attention, and I can only assume that it caught the attention of the jurors as well. When they went, oh yeah, they lied to us about the Sallyport video. They flipped it, and they went to such an effort to intentionally, well, he's going to talk about it. I'll wait for him to get to it, and then we'll talk about it again.
They'll magically turn 3 pieces of plastic into 5 right before your eyes. And even when they're caught with their own lies, they won't blink, they don't sweat. They'll just look you in the eye and demand, pay no attention. You folks look the other way. Ladies and gentlemen, there was a cover-up in this case, plain and simple. You'll surely say to yourself, I don't want to believe it. I don't want to believe that could happen in our community. But sadly, over the past 8 weeks, you've seen it right before your eyes. So how does a cover-up happen? How could that happen? Well, let's count the ways, shall we? Handpick your investigator. Make sure it's someone we know, someone on our side. Keep them close. Offer them help. Offer them a gift. Have secret friends and family meetings. Get your story straight. Delete your call history. Make mysterious phone calls at 2:22 a.m. Delete Google searches. Monitor police activity. Get rid of evidence. Get rid of your dog. Destroy.
And again, it's brilliant. He keeps talking about getting rid of the dog, because huge number of people are pet owners, and most pet owners tend to like their animals more than they like people. So getting rid of pets under mysterious circumstances almost never sits well with pet owners. And well, there's the documentary of the cat people that they tracked down the nut job through his YouTube videos that was harming cats on his YouTube videos. The whole army of cat owners around the entire universe started piecing together bits and pieces of his video to find out where he lived, and it turned out he was also killing people. So yeah, the documentary was called "Don't Fuck with Cats." So don't mess with pet owners. They don't like it when you do things like that.
Destroy your phones. Destroy your SIM card.
Yeah, John Wick doesn't like it either.
For the investigator, decide on a narrative early on. Don't go to the crime scene. Don't take witnesses in for questioning. Question all the witnesses together. Ignore witnesses who don't fit your narrative. Allow friends and family to contact those same witnesses. Don't record interviews. Write vague and false police reports. Omit witnesses' names. Omit witnesses' interviews altogether. Don't photograph the evidence. Don't conduct any forensics. Don't document the evidence. Don't document the logs. Don't create any logs whatsoever, and don't maintain a chain of custody. Keep all the evidence in the hands of one person and then manipulate that evidence, including videos. Don't turn over videos. Invert videos. Turn 4:16 p.m. into 5:30 p.m. in affidavits. Turn
The-
3 pieces
the
of
vehicle.
taillight into 5 pieces of taillight. Delete 42 minutes of surveillance footage, hide personal relationships, make this case cut and dry, and ensure the homeowner, quote, never sees any shit because he's a Boston cop. But
Good. Now he's getting to the rhythm. Now he's getting the flow. It took him a few minutes to knock the dust off and to get relaxed, but now he's in his stride. And he just went through a little more than a minute long litany of things that these police officers did, and more importantly, didn't do, that you would normally expect to see in a normal case, let alone a case where they're investigating the murder of a fellow police officer. So he's doing a fantastic job now. Said it took a little while for him to catch his stride, but he's definitely there now. Island with the $5 says, was struck by difference in ability to construct a narrative between Jackson and Lally. Lally seemed wandering and half bored. Jackson painted a picture. I completely agree with you. And if we get as far as Lally's closing arguments, we'll talk definitely about that. And Jacob's Proud Madre has also dropped 5 Legal Vices memberships. If you got one of the 5 Legal Vices memberships from Jacob's Proud Madre, or previously it was Aussie Wombat gave us 5 also, make sure you gave them a super special thanks for the free membership. And at the end of the month, it's going to ask if you want to redo it. If you do, great. If you don't, whatever. We're just glad that you're here in chat right now, hanging out with us. Thank you very much for the support there. And Chloe Albert's Revenge with another $2. Prom and grad season complicating the jury. Yeah. Well, let's just hopefully they won't have to worry about missing the bus today. And Shell B says, where can I find that documentary? It might still be on. It was originally on Netflix, I think. The Don't Fuck with Cats. Check Netflix. If not, I'm not sure where it is, but that's where it was last time I saw it. All right, let's jump back. He's going to make a big point right here.
never sees any shit because he's a Boston cop. But most importantly, pick your patsy.
Pick your patsy.
Pin it on the girl. It's not that it could happen. It's that every single one of those things I just mentioned did happen.
Again, a brilliant line. These aren't possibilities we're talking about. It's not possible that things could happen. They actually did. And then he addresses each one of them in detail.
In front of you. But this sort of injustice can't happen in a vacuum. So what about the prosecution? What about the Commonwealth? What does it look like when the government picks a narrative and then tries to form a prosecution around the narrative instead of the other way around? Looks a lot like this. If you don't have actual evidence, just throw every single thing you can against the wall to see what sticks. Drag her through the mud and make sure you attack her character. And that's what you saw in this case. The Commonwealth spent much of their time and resources trying to vilify Karen Reed. They desperately resorted to calling witnesses to talk about Karen Reed and John O'Keefe's arguments. They even stooped so low as to call the children and put them through this ordeal. All to say that John sometimes got upset because Karen was too kind, too nice, spoiled them too much.
And I think he may have a very valid point here. It's never really an easy decision to put children on the witness stand, to question children, let alone question children about the alleged murder of their uncle. It's, to turn them necessarily or unnecessarily against their uncle's former girlfriend. that might sit really, really poorly with the jury. Particularly, we don't know what was said other than what was reported, but basically what he said, they reported they had arguments sometimes because he didn't like the fact that she was lenient with the kid, too lenient with the kids, and too nice, as Jackson said. And that might come back to bite the prosecution in the ass. You don't submit children to murder trial examination unless there's a very, very good reason. Yes, and especially as Island says here, neither child witnessed anything that had anything to do with the night in question. It was just there to say, oh, look, she has a bad character because they had an argument. They had occasional argument about being too nice, so she murdered him. Yeah.
Their arguments illustrated what anybody could imagine is a normal set of ups and downs for any couple. Even on January 28th, they talked it out, they communicated, they worked out their issues, and they had a nice, affectionate evening out with their friends. And you don't have to take my word for it. Pull the tape, as they say. Look at the videos. C.F. McCarthy, Waterfall. What are the words that every single person who testified in this case used about Karen Reed and John O'Keefe that night? Getting along, no issues, good mood, happy, affectionate, even lovey-dovey. No issues, no toxicity. They were a loving couple right up into the time Karen Reed dropped him off and he walked into 34 Fairview. If an argument with a loved one is a motive for murder, folks, we're all in trouble. Speaking of which, what is the evidence that John went into the house? The Commonwealth will tell you, undoubtedly, no, he never went in the house. And they'll point to certain witnesses who they say didn't see him go in. Well, the question you have to ask yourself is, can you rely on that? First, these are all people who are related to or committed to the Alberts in some way or another. That all-powerful Canton family, it's easy to say, I didn't see something, because how can that really be challenged?
Right. And see, this is a setup for what Lolly did. That's what he's saying. Everybody that says she did something, everybody that said something incriminating about her is all part of this same little clique. They're all part of this same little, two-family clan. And that is essentially what Lolly talked about his entire hour, was this person said she heard, I did it. This person saw this one thing. The only person that saw this dark lump on the lawn. And he says these things that nobody can really challenge because nobody can verify it either. Only one person saw something. Only one person heard something. Only one person did something. And they're all part of this little group, and you can't get to it. And that's what he's talking about here. How do you do this? Good foreshadowing.
Some actually may not have seen John walk into the house. They were in the kitchen, as you recall, from Nicole. Third, at least one witness, Brian Higgins, forgot his narrative, at least for a second, and he admitted a man did, in fact, come into the house. And when he was caught and asked to describe that man, he had to. It was a little bit vague. You remember what he said. He was tall with dark hair. That was a telling slip of the tongue by Brian Higgins. But what's the real evidence of the unbiased data, the data that's not connected to the Albert family?
Now, this is what I liked. Everybody has to get their little quotes, their little catchphrases, their little things they're doing out of the way at the beginning. He stumbled a little bit at the beginning, I thought. Yeah, it was a little bit. And then he went into this section, all of the what essentially amounts to unfounded, unsupported, and inarguable statements and assertions by the prosecution's witnesses. Now he's saying, we know they lied about a lot of this. We know they lied about many, many things on many, many occasions, and you can put that aside. Let's look at the non-them witnesses. Let's look at what the science shows.
How about John's Apple Health data? It shows that at 12:21 a.m., an important time, John arrived. That's established by the monotonic time clock that you heard about in this trial. It was on his phone, and that represents a huge problem for the Commonwealth. It shows that he took 80 steps and ascended or descended 3 flights of stairs at that time. And that makes perfect sense, doesn't it? It matches. Walks into the house, goes directly to the basement. There's your 80 steps and your descending flights of stairs. The big problem for the Commonwealth is he wasn't outside at the car ascending and descending stairs, wasn't climbing on top of the car. So they'll tell you, wait, don't look at the Apple Health data. Look at this other thing called Waze. But Rick Green explained that if you apply the 3 minute.
And what the Waze thing did, and Lolly's going to talk about it a little bit during his closing, is the Waze deal. It relies on another internal clock that's 3 minutes off of this, but that puts the 86 steps and the going up 3 flights of stairs half a mile away from the Albert home. So that was what they were saying. Oh, you know, he was when he went up and down these flights of stairs, when he took these steps, he was half a mile away. But what Jackson here is saying is there's a 3-minute difference in time between these 2 internal clocks. And if you adjust the Waze with the Waze data, which relies on the 3 minutes ahead clock, you pull that back to the Apple Health data clock, which uses one of the other 3 clocks, they match up perfectly.
Minute offset that is built into that monatomic time, it aligns perfectly. They don't want you to see that. They don't want you to pay attention. They want you to look the other way. But even more importantly, at approximately 12:32 a.m., someone holding John's phone takes another 36 steps and travels 25 meters. Why is that so important? Because by 12:32 a.m., Karen Reed was gone. She had already left the location. She left at 12:30. Trooper Garino told you that Karen Reed's phone connected to John's Wi-Fi at what time? 12:36. It is undisputed in this case that it's a 6-minute drive on a good day from 34 Fairview over to One Meadows.
And one thing I like to do with these trials also is to go back and review the opening statements to see whether the prosecution proved the things that they said they were going to prove, and whether the defense managed to support what they said they were going to support. Go back and watch this. Go back and watch the opening statements of the prosecution, because Lally said, our evidence will show that Karen Reed struck John O'Keefe with the SUV at some time between 12:40 and 12:45 a.m. But during the course of the trial, we got the prosecution's witness to say that she automatically logged into John O'Keefe's Wi-Fi at 12:36 a.m. And from the time that witness made that statement under oath, Lally had to try his damnedest to walk back that time to at least 12:32 so that or 12:30 so that she had time to get home. Now, one thing to notice, whether we get to it here, whether you stick here and watch it with me here, or whether you watch it on your own, but rewatch the prosecution's closing arguments and see if you can catch a mention of when Karen Reed was supposed to have struck John O'Keefe from the prosecutor in their closing statements, and see if you can find it.
She was gone by 12:30, and John's phone was taking 36 steps and logging 25 meters at 12:32 after she left. So don't be fooled. John walked into that house, after which Karen drove away, and the scientific data all prove it. But also, Ryan Nagel and Heather Maxson prove it. In addition to the Apple Health data, Ryan and Heather both independently testified that they passed Karen's SUV as they drove away after talking to Julie. And Karen was alone in the SUV. John was not with her. He wasn't in the car. He wasn't standing outside the car. He wasn't sitting beside the car. He wasn't laying on the ground beside the car. He was nowhere in sight. There's only one other place that John could have been, and that's in the house. Exactly where the Apple Health data places him. so it all fits. And Ryan was right behind her, remember, staring at her taillights, undamaged, brightly lit. That brings up another difficulty for the Commonwealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was...
Yeah, Jennifer McCabe had a few problems. Jen McCabe, not the greatest witness, testimony-wise, attitude-wise. She was a disaster. If you're a prosecutor and you need someone like her to get your evidence out, you need to have some serious conversations with her about how to act. The absolute, which would, you know, we called it the severe, what did we call it? Cross-examnesia. It was the, I think Legal Bites coined that term, the severe cross-examnesia, where you know all the answers and you're calm, cool, and collected on direct examination. But when it's time to answer questions on cross-examination, you gain 100% amnesia. You can't remember anything. You try to put the defense on the defensive by saying, show me where I said this, show me where I didn't say this, show me that, do this. You're scowling, you're biting, you're angry, you're bickering. That looks terrible to a jury. Whether you're right or not, it looks terrible. But let's let Jackson focus on the issues he wants to focus on. Before we get there, Chloe the dog, Chloe the dog says, you'll never find me in Vermont, bark, bark, woof. Chloe also says, I did it. But Chloe Albert's revenge might have something to say about that. Cody Height. Hey, Cody Height, how are you doing? Remember, for 2 months, what if any verdict will be reached? Well, I know what I hope it is. I hope it's a not guilty verdict. But we'll just have to wait and see, won't we? All right, let's get back to more Jacksoning.
Wealth, and that's their star witness, Jennifer McCabe. You'll recall that Jennifer McCabe claimed that she was looking out the door, staring at that SUV over and over and over again from 12:29 to 12:50. She was very specific about that time frame. But we know that the SUV was gone from 34th Fairview by about 12:30. Had to be in order to connect to the Wi-Fi at 12:36. So unequivocally, Jennifer McCabe was lying about watching that SUV, and it makes you wonder why. And to add to that deceit, she was also blatantly lying about the calls to John's phone. You remember that colloquy back and forth. She said that every single one of those calls to John's phone during that time was a butt dial.
And there was a lot of them. I believe 7. I believe there was 7 phone calls in the space of 19 minutes, if I recall correctly. 6 or 7 calls in the space of 19 minutes. And they did a very good job. The defense did a very good job of saying you have to unlock your phone. You have to manipulate the most recent call or the phone call item. You have to select the number. Then it has to ring through. And then if you hang up, then you have to do all that in reverse. So you have to do at least 6 manipulations to butt dial and butt hang up. And with 6 or 7 calls, you're getting 42 different manipulations with your butt cheeks over the space of 19 minutes to call and hang up on people. That was a bad thing for her to say. And it's weird that recently, since iPhone became a thing, I think I've butt dialed or pocket dialed or whatever you want to call it, maybe 2 or 3 times in the last 10 years. But these were people, Higgins, Albert, McCabe, they were all butt dialing each other at the same time, repeatedly.
How are those lies connected? And why are they connected? Jennifer McCabe knows. Was she butt dialing John over and over? Or was someone looking for John's phone that went missing?
And isn't isn't that more likely than people were butt dialing each other and she was butt dialing John 7 times in the space of 19 minutes? John's out there and they're like, shit, where's his phone? And they're calling, listening for the vibrations, listening for the rings, trying to find where the damn phone is. But it's under him out in the snow. That to me is Occam's razor. That is the most obvious answer. That's the most logical answer amongst any answers that have been presented. And good on him for highlighting that, I thought.
Let's talk for a second about what actually happened in the time leading up to everyone going to 34 Fairview. Brian Albert, Brian Higgins show up drunk at the waterfall. They'd been drinking in the afternoon. You know about the flirtatious texts that were sent between Karen Reed and Brian. Higgins was clearly pining over Karen, but for her, the flirtation had ran its course. It was done. She was happy and committed to John. You could see that in her actions with John that night. You don't have to guess. Brian Higgins, however, you can see in his actions, he wasn't quite so satisfied and he wasn't done. His text message, well, meaning, what the hell, Karen? What about me? Seemed aggressive, seemed annoyed. He didn't like being ignored. That was pretty clear. So he's 5 or 6 whiskeys deep into the night by this time, and she continued to ignore him. Then oddly, Higgins, who doesn't know John all that well, seems to want to coax John to 34 Fairview. I draw your attention to the waterfall tape if you want to take another look at it. It's at the 11:57 mark, between 11:57 and 11:58. Take a look at that tape. He's just about to leave. Higgins is just about to leave. He points over at John and he motions for him. Come on, come with me. And then at 12:20, he texts him, you coming here? This is a person he doesn't really know and didn't really talk to that entire night. Ask yourself, why was Higgins so insistent that John go to 34 Fairview that night? And then there's that sparring and fighting that he and Brian Albert were engaged in. Of all the things they could be doing, this is what they were doing just minutes before John O'Keefe walked into that house at 34 Fairview. We know that once John actually did walk in the door, it's about 2 steps, 4 feet or so, 2 steps for an adult male to reach that basement door. Remember, everybody was gathered in the kitchen. That's what Nicole Albert said. And every single witness agreed that at some point, Brian Higgins and Brian Albert left the group and went to another room. Where did they go? Where did they go together? Another important point. Chloe was not upstairs. Brian Albert slipped in one of his testimony that he provided. Quote, I was watching Chloe downstairs, monitoring her because of the other people in the house. She's not good with strangers. Remember that testimony.
Yep, that was a big moment. I think that was one of the big moments in the trial. When we said he was watching her downstairs. Also, was the text messages saying, make sure you tell them that he didn't go in the house. I thought those were some pretty big parts of the testimony.
So what happened next? We absolutely know that John was in the house. The data, Ryan, Heather, they all established that. We know that John ascended or descended stairs. We know that Brian Higgins and Brian Albert excused themselves. How long does it take to have a crossword? How long does it take to have a fight? How long would it take for Brian Higgins to say to John, you know, your girl's been texting me. A push, a punch, a fall, pull Chloe off his arm, and now it's done. What is that? 5 seconds? 10? Doesn't take long at all. And then the panic sets in. It wasn't intended to go that far, but what's done is done. And then some very, very odd things start happening at the Albert household. Very odd indeed. What do we know? We know through the testimony and key swipes that Brian Higgins very oddly goes directly to Canton Police Department. Why would he do that? After a night of drinking and partying, why go to CPD when you're drunk? What was so important there? He couldn't even get his own story straight. First, he said it was administrative work. Then he said he was moving cars. Then he said it was a factor of both.
It's maybe it's not weird that an ATF agent has a freebie office, local office there in the local department. But again, like you saying, you're out drinking, you're liquored up, and plus you're driving. You know, you're an ATF agent. You've had a bunch of whiskeys, and then just suddenly, for no reason, you leave a party and decide that you have to go back to the police station and do some work. Oh, looks like there's something happening in the court again, people. Hang on, we're gonna go see that. Let's see, present, share screen. What's going on in the court? Let's start up this. What are we doing here? Get over here.
I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it.
All right, let's go back a little bit here. Here we go.
22.
What is back to session and may be seated.
22117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it, was you agree that there needs to be not guilty options for subordinate charges under count 2?
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge. And that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you.
I agree with
Mr.
that.
Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise for the court, please.
Ooh. I'm kind of speechless about that. I completely, absolutely, 100% agree with Jackson on that. Absolutely agree with him. There needs to be a guilty, not guilty. You find the guilty. Okay, let's start up with the deal. You find the defendant guilty. Do not proceed to other questions. There needs to be another box. You find the defendant not guilty, then proceed to the next charge and go through there. You find not guilty there, you proceed to the second lesser included. I completely agree with him. If it just says you find her guilty of this, guilty of that, what happens if they come back and find her guilty of both of them? What if they come back and they find her guilty of everything? You can't do that. And I thought Jackson was absolutely spot on when he said, how do they find them not guilty? Oh, it's up here in the corner. Yeah. I'm kind of stunned by that. And then she tries to, well, Mr. Yannetti, you've seen it. He's like, yeah, well, no, not really. I really haven't seen it done this way before. And she's like, well, this is what we do. Thankfully, the jury wasn't in the room to see Karen do whatever she did. She apparently laughed. She laughed at the judge, or laughed at the situation, or laughed at Yannetti, or she laughed at somebody. And already upset Judge Bev got pissed. Some of you are saying you need to go back and rewatch this. Let's go back and watch this. Do we want to go back and watch this again? We're going to watch this one more time. All right, where are we? Listen to his arguments. Okay, people said, yes, that's good because I'm already back. Listen to his arguments. Essentially, they have, and this is what I was saying, it was a checklist yesterday, because it's always done the way that he's saying it. Every juror form I've seen, has it for each charge: guilty, not guilty. Guilty, proceed no further. Not guilty, proceed to next charge. Something along those lines. So the jury can say, we find her not guilty of the first charge. Because all right, I'm repeating myself, but just listen to what he's saying. He's asking the question. It only says guilty of this charge, guilty of this charge, guilty of this lesser included charge, guilty of this lesser included charge, or there's one box for not guilty of everything somewhere on the form. And he's saying that's bullshit. They look at the first one. How do they find her not guilty? Oh, they look for the box up here. Let's go. We're rewatching this here.
What is back to session? You may be seated.
22-117.
All right, so why are we out here?
Your Honor, I just saw the verdict forms, and as we discussed yesterday, the amendments the court indicated it would make a verdict.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
You said before you were tired and you needed to think about it, was you agree that there needs to be not guilty options for subordinate charges under count 2?
I said that it made sense to me, but no, I did not change it upon looking at it, because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
I ask you a question. I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
Great
It's
answer.
appropriate.
Different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty. And on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, apparently that's how it's going to be because of the court's ruling. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't, Your Honor.
I actually haven't, Your Honor. That's a yeah, good on Yannetti for actually saying, no, Judge, you're wrong. I haven't seen this. No, I haven't.
A verdict of the subordinate charges.
Okay. I disagree with you. Ms. Giannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't, Your Honor.
Have you had no lesser includeds?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay. I disagree with you. All right. Excuse me. This is funny, Ms. Reed. All right. We're done.
All rise to the court, please.
I don't like that at all. I think she's wrong. I don't think she's wrong. I think Jackson is more right. Does that make sense? Well, there's one thing I want to look at here, which was very, very helpfully and thoughtfully provided to us by Hayden from Aussie Overlord. Here is a draft. This is just a draft jury verdict form. Just a what do you want to call it? An example of a jury verdict form. Should we put, no, that's not what we want to do. Let's just put me down here. I don't know if this is the same basic one they're using here, but again, this is just kind of an example for the Commonwealth of Massachusetts District Court Department of Trial Court. Commonwealth versus whoever, jury verdict. We, the jury, unanimously return the following verdict. We find the defendant not guilty of the offense charged or any lesser included offense. We find the defendant guilty as charged of this, and this, and this. We find the defendant guilty of the lesser included. We find the defendant guilty of the lesser included. Now, I will say that when Hayden sent this through, I looked at it in the entire kind of bird's eye view like this, and I had to look at this thing 4 times. This was just me, just right now. I had to look at it 4 times before I noticed number 1 said, we find the defendant not guilty of the offense charged. I had to look at this thing 4 times before I saw this. We find the defendant not guilty of the offense charged or any lesser included offense. All I was saying was, we find the defendant guilty. We find the defendant guilty. We find the defendant guilty. Share screen, Jeff. I am. I am sharing the screen. I don't know what more you need. Yeah. I think this is just a bad form. That's what I said, Brazilian Babe. I said this is probably not the one they're looking at. This is just an example for them, and I don't even like this one. I don't know what theirs looks like. I don't have a link to theirs. So what it should say is charge one. This is the elements of the charge. This is what the charge is. Guilty, not guilty. If not guilty, proceed to lesser included. It should say something like that. Check guilty or not guilty and decide whether you need to go. This is just an example. So let's not get our all caps knickers in a twist here. All right, we don't need the 2 jurors were dismissed. Oh yeah, I brought that up because someone was saying that juror 12 and juror 13 had been dismissed. They were the ones that were dismissed earlier. Let's get through these super chats, by the way. Then we'll jump back into this into the closing arguments here. Where are we at? How many do we have to get through here? It's doggo cam time too, by the way. How many butt calls does the Vices have each weekend? None. None, as a matter of fact. Nicolina 777 with the $5 super chat. They removed 2 more jurors, 12 and 13. Jurors 12 and 13, they were the ones that were removed previously. There's been a total of 3 jurors removed. Juror number 12 was the first juror that was removed, and juror number 13, I believe, was the one that was removed last Friday, and then the other one that was let go yesterday. So there's been a total of 3, 12, 13. I think it was 3 or 4 yesterday. So that's that story. And EMT 2666 with the $2. I found if Karen is found guilty, can the feds override it? No, but depending on what the outcome of the federal investigation is, it would be up to the appellate courts to decide what weight to give whatever comes out of the federal investigation on appeals. And Yuki Roma, adore you, but you look like Professor Hinkle waiting for Hocus Pocus and Frosty to appear in that hat. Burl Ives. Burl Ives, wow. That's it's Christmas time. Frosty the Snowman. This is quite a nice hat, actually. So curb your tongue, knave. Disney Nerd 85, member for 9 months. I served on a jury back in November of last year, and all the charges had a guilty and not guilty option. This is insane to me. I do not disagree with you. Chloe Albert's Revenge with the $2. Whoa, is there an imposter? Call Dog 11. No, it's the battle between Chloe Albert's Revenge and the other Chloe the dog in chat here. And Duncan Idaho with the $5. I'd be laughing too if my life were on the line and the judge in charge of the whole farce was a belligerent incompetent. Youch, that's harsh, Duncan Idaho. Dang. Wow. Woe is woe. If Jackson is arguing this, does that mean the jury is finding her guilty? No, he was arguing this because he thought she said she would make the change. And then I guess he looked at the verdict form and he saw that she hadn't made the change that he thought she was going to make. She said, I never said I would make it. I just said I would think about it, and I thought about it, and I ain't making the change. And Chris said, Legal Vices, what do you think of the comment she made to Karen Reed at the end? If Karen Reed was smiling or laughing, it was completely justified. You just don't do that in court. It's the judge's domain. It is the judge's kingdom or queendom. And, you do shit like that, the judge is going to call you out on it. So that's why I said I was glad the jury wasn't there to see it. Terry D, who's been a member for 2 months. Doggo Cam yet? I need my support potato dogs. Yes, we have gotten to that point. It is that time that we affectionately like to call release the hounds. So we'll get the closing arguments back up, and once we do that, we shall release the hounds and turn on the emotional support potato pig dog cam for all of you all, because you guys are so dang awesome. Give me a minute to switch things up here. And Let's see. Share the screen. There we go. Back to Jackson's closing arguments. Let me put up the banner so people know what's going on. The banner that says we're just waiting. All right, people. Let's get back to the closing.
To gather intel. Ask yourself, why go? But the odd things keep piling up, and here's another. Chloe was the Albert family pet. Not only did she appear to be gone from the house that morning on January 29th, nobody saw her there. Even Jim McCabe admitted that I didn't see her there. But they actually got rid of the dog altogether. Within months of this incident, the dog was gone, out of the house, rehomed, never to be seen again. This was a dog they had had for 7 years. Also a dog who had a bite history. Why was it so important to get rid of that dog? Was there something about the dog they did not want law enforcement to find out? Recall what Dr. Russell said. She's seen up to 1,000 animal attacks. In her expert opinion, John's right arm, those injuries are from an animal, quote, most likely a large dog.
Well, one thing, again, we talked about it. People just don't like it when you have the favorite family pet of 7 years and you just mysteriously rehome it. It apparently bit a couple of people in May, which was a couple of months after this happened. So it's got a history of biting people, but it's been rehomed, but they wouldn't say where it was. I think it was during one of the first couple of witnesses. One of the first few witnesses the prosecution put on that the defense finally learned where the dog was. Yannetti seemed very surprised at the statement that the dog was somewhere in Vermont because there had been orders to produce the dog, clearly to take tooth imprints and whatnot, but they never did. So for those of you who don't know, this white dog over here, this is Yoda, and this is the butt of Yoda's younger sister Strawberry. They have a little eczema kind of thing going on here, so they're getting skin treatments. That's what the white medication on Strawberry is. All right, so those are the two emotional support potato pig dogs that I've got here.
Dr. Russell's testimony, I'll remind you, was undisputed by any witness for the Commonwealth. But there are more odd and unexplained things. After a night of drinking and hanging out and partying, after being together for the entire day at 2:22 a.m., Brian Albert decides to call Brian Higgins. That call was missed, but 17 seconds later, Higgins calls Brian back, and they speak for 22 seconds. Now, that call is odd and suspicious enough, and just in and of itself, the fact that the call was made. But what's even more incriminating is that both men, both of them, lied about the calls happening. They both claim astonishingly that those calls are, you probably say it with me, the butt dials. Amazing. But Albert and Higgins take it a step further. Not only did they claim that they were making calls as butt dials, but they were answering calls as butt dials. And Higgins seemed awfully defensive about that call. Didn't you? Remember on cross-examination when I was asking him, can you have a conversation in 22 seconds? He unequivocally said, no, that's impossible. It's not reasonable. You can't do it. Well, let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows.
And I'm going to go through this whole thing again. This is one I was very, very happy he did this. He didn't do it the way I thought he should do it, but hey, it's his case, not mine. He wanted to do this during the actual case. I believe he wanted to do it during his, what point did he want to do this? Well, I think it was when Higgins was on the stand. He wanted to just sit there because I believe it was Higgins that said, you can't have a conversation in 22 seconds. And he wanted to just sit there quietly for 22 seconds and show people exactly how long that is. And it is 22 seconds is surprisingly long. But he's doing it. He's giving an example here. I wish he would have just sat quietly for 22 seconds, but he did this hypothetical phone call. He showed that it's possible to exchange this information in 22 seconds. But I want to do this right now. Dead air is always a bad thing, but Higgins said you can't have a conversation. You can't have the conversation in 22 seconds. This is 22 seconds starting. And this is all around a butt dial. There was a butt dial. Then there was allegedly it was allegedly a live phone call for 22 seconds. He said, well, we couldn't have been talking about anything because you can't have a conversation in 22 seconds. Here is 22 seconds starting now. And stop. That was exactly 22 seconds to the 10th of a second. I'm good at that. That was exactly 22 seconds. You can exchange an absolute ton of information in that short of a period. So, yeah, there we go. No, I wasn't muted. It was called an example. We were doing an example. All right. So yeah, that is a long time. You think 22 seconds is short, but it is actually a very, very long time. All right. People are saying the form is up on Tom's. What is a Tom's? I don't know what a Tom's is. If someone has the form and wants to shoot it on over to my Twitter, we can check it out. Oh, we do have the form here. Someone's already. Farm Girl Mom is way ahead of me. All right. All right. We have the actual slip here. So let's show the actual slip, shall we? All right, people. Here is the actual form. Screen share, window. Oh, damn it. Hang on. It's on the Twitter page, so I can't enlarge it. Let me do this. Open image in new tab. There. Now we can enlarge it. I hate the fact you can't just enlarge your Twitter screen. Stop screen, share new window, and there we go. Let me back out of this. This is the actual form here. Commonwealth, Massachusetts, Commonwealth v. Karen Reed, verdict slip. Offense 2, manslaughter while operating a motor vehicle under the influence. The above entitled case, we, the jury, say the defendant is not guilty. Two, guilty of the offense as charged. Manslaughter while operating a motor vehicle under the influence. So this is for the manslaughter. Do we have a verdict slip for the second degree murder? That's what I want to see. But anyway, this has the lesser included. So they find him not guilty, or they find them guilty as charged of this, guilty as charged of the lesser included offense, guilty of lesser. So they're saying, okay, we find them not guilty of manslaughter. This is what he's arguing. This is the offense they've been charged as. They've been charged with manslaughter while operating a motor vehicle under the influence. Are they not guilty, or are they guilty? They're not guilty. You check off the box, not guilty of the offense of manslaughter while operating a vehicle. If you find she's not guilty of manslaughter while operating a motor vehicle under the influence, then you go to the lesser included offense. So you go down, okay, we found her not guilty of this offense. So then you go down to the lesser included offense of involuntary manslaughter. You find her guilty, or there is no box to find her not guilty of the lesser included offense of involuntary manslaughter. There is no box to find her not guilty of motor vehicle homicide. So they're saying, yes, it's fine for the offense charged, manslaughter while operating a motor vehicle under the influence. That has not guilty and guilty. But if they're not guilty of that, you go down here. And your only choice is guilty. I get what he's saying, and this is much worse than the form we just read. So yeah, I see what he's saying completely clearly now. This is a shit form. This is a shit form. But her argument is, no, you choose one of these boxes. It doesn't say choose one of the boxes. The other verdict form said choose one of the four. You can only choose one of the four. This just has the four boxes. There is nothing that says only choose one of these four. This is a terrible form. Yeah, you're right. Town crier, the not guilty is for all charges, but it doesn't say that. It's very easily read to be the offense of manslaughter while operating a motor vehicle, not guilty or guilty. You choose not guilty. Okay, let's look at the lesser included. Our only box is guilty. It's very easy to interpret it that way. So I think that the Jackson is right. Regardless of whether or not this is the way it's always been done, it should not be this way. Caligula said legal vices is potentially grounds for an appeal. That's what Jackson just said. He said, look, if they find her guilty of involuntary manslaughter, that's instant appeal because there's no option for them to choose not guilty of the lesser included offense of involuntary manslaughter. I like that argument. This is a bad form. All right. That's a little bit of courtroom drama. We've apparently had a couple of incidences of courtroom drama. We saw that was it Jackson was going after the court clerk about whether or not something was admitted into the record. Maybe this was it. Maybe this is what they were talking about. Doesn't the state and defense not review these forms before they are published and presented to the jury? Well, see, that's what triggered this. Apparently, Jackson raised this point yesterday with the judge, and Jackson said that he heard the judge say, I'll make the change tomorrow. I'm tired tonight. I'll do it tomorrow. But the judge said she never said that. She said, I said I would think about it. And I thought about it, and no. So he was saying, I thought that's why they're talking about it. He said, I thought you said you were going to change this. You didn't change it. So that they do see it. They did discuss it. And apparently there was a difference of opinion about what she said she would do. All right. Well, that's interesting. Nice little drama there. Let's review some of the super chats here, and then we're going to get back to the closing arguments. Hey, what are you doing over there, dog? That looks weird. I can see you're licking Yoda's foot, but not everybody can see that. It looks really, really weird. All right. Terry D, dog cam yet? Oh, yep. We've got that. Chloe Albert's revenge. She likes to say this is normal in Massachusetts. So was burning women alive, and we all know how that went. So was burning women alive, and we all know how that went. She's kind of out of her mind, but what do we expect? I think she's completely wrong. Just because you've always done something some way doesn't mean that's the way it should be done. Chloe the dog, I don't bite. I gnomed. I'm happy on the farm. And Angie Hammond with the $5. Sent you the form on X. Aha, that was you. Thank you so very much for doing that. You were one step ahead of me. Island with the $5. Island with the $5 says, literally rehomed my dog to a farm with my parents. Check on him and visit. He's living his best life, and I know where he is. No mystery. Where's Chloe? Exactly. Where is Chloe? We need proof of life for Chloe. We need proof that she's not encased in concrete in the cement pond behind the house. Cloak and Glomer, check your email. I sent what is the actual verdict form. Thank you. Thank you for sending that. You got beat out by Farm Girl Mom, aka Angie Hammond. Thank you so much. Appreciate looking out for me, peeps. We got a lot of it. We've got Amanda there. We've got lots of people are sending me the form. There's lots of people sending it. So thank you very much to everybody that sent the form. And where are we? Thank you very much for the super chat too. Joe Pottinger. Hey, Joe Pottinger. Remember, for 13 months, I've been playing catch up with this case for the last 4 days of court. Thank goodness I can now join live for the verdict watch and the drama, the courtroom drama. And our last monthly membership here. Member for 4 months, Caldrack. Apparently, I forgot to use this member chat when I subbed again. Well, have a great day and not guilty. Thank you all for those supportive chats. Let's jump back into the closing arguments while we wait for the next little bit of drama to find its way into court. Let's go back to Jackson Cam. And oh, by the way, we're 1 hour and 51 minutes into this right now. There's 1,868 of you, nearly 1,900. Do we need to slow down chat? I'm cool with chat the way it is. Put a 1 in chat if we should slow it down, and a 2 if we're good. Just do that for me if you would just do that, please. 1 if you would like me to slow down the chat. 2 if you are just comfortable with it the way it is. All right, looks like you're all happy with the way it is. Great. All right, you don't need to vote anymore. The 2s have it, so we will leave it where it is. I was just looking out for you guys. I didn't want it to be too busy for you to have fun and enjoy. Right. So, thank you very much. And Straubs, there you go. What's up? What's up, dogs? All right, Jackson, go.
Can't do it. Let's test that out. Hey, did you make it over to Canton? Yep. Haven't been any calls. Nobody knows a thing. All right, don't talk to anybody until we talk again. Okay, fine. And by the way, come back over. I need help moving something heavy. How long did that take? 15 seconds, maybe? But the odd behavior isn't done yet. 5 minutes after that call that we just talked about, Jennifer McCabe is on her phone at her house, Google searching how long it takes for someone to die in the cold. That was at 2:27 a.m. That timeline seems to fit, doesn't it? And it fits a very telling and a very clear story. That search became a focal point of the Commonwealth's entire case. This case was starting to look a lot more like the defense of Jennifer McCabe than anything else. That's probably because there is no innocent explanation for that Google search at 2:27 a.m. None.
Yeah, 2:27 a.m., nearly 3.5 hours before anyone knew there was a reason to be searching for how long it takes for someone to die in the cold.
At the end of the day, clearing away all the confusion, the Commonwealth's experts were left with 2 things that are true. First, neither of their experts could absolutely rule out that Jennifer McCabe made that search at 2:27 a.m. Neither. And second, the only person to use the actual phone model, the actual data, and the actual precise operating system was Rick Green.
And that was good too, because they had the Celebrite guy, the guy whose job it was to do this, to to extract this information and to explain for the prosecution how this could not have been done at 2:37 or whenever the hell it was done. He didn't use the proper version of the software. He didn't use the proper iOS. He was comparing apples to oranges. And the defense witness was and he said, because he said it was as close to the actual iOS version as he can find. Any version of Apple's iOS, any past version you want to find is a Google search away. I don't know how many times I had to roll back my phone when I was using Apple software, and they'll tell you in the iTunes store you can't roll it back to an earlier version, but you search online and you can find an earlier version. So that was just a flat out lie.
And he was clear. That search was at or before 2:27 a.m. And then it was deleted. So what else was going on at or around this same time, when all this suspicious activity was happening at the Albert house and the McCabe house? 3 minutes after that search and 8 minutes after the Albert Higgins 2:22 a.m. call, Brian Loughran drives down the street in his snowplow. And he told you that there is no body laying on the lawn at 34 Fairview at 2:30 in the morning. Importantly, he didn't just simply say he didn't see a body, he wasn't paying attention. He said there was no body there. He knows the property, he knows the owners, he's grown up with these folks, he passes by all the time, not once, not twice, 3 passes. There was nobody on that lawn, period, at 2:30 a.m. And what other suspicious thing happened that night? By 3.
And isn't that some shit that the prosecution knew the identity of the plow driver, knew the route he drove and the times he was there, and they didn't bother to question him. They didn't ask him any questions. They didn't want to talk to him.
30 a.m., someone moved a Ford Edge in front of the very area that would obstruct the view of where John's body would ultimately be discovered. Who's the only person in this case that you've heard about with Ford Edge? Brian Albert. Remember, as you're thinking about this, the basement at 34 Fairview is serviced by a bulkhead. It's a quick and convenient door to the backyard. And that backyard is serviced by a side fence. And that side fence is easily accessible to the front yard at the side of the house. Which side of the house?
Interesting thing here, Susan New York says he's not watching the lawns when plowing the road. He's paying attention to the road. If you listen to his testimonies, and also we actually had some plow drivers here in chat. They're saying that you were definitely looking to see what's on the sides. You know what's in front of you, and you see what's in front of you, but you're also making sure you're seeing if anybody's backing out of driveways, if there's animals coming out, if you're too close to the edge of the road, if there's fire hydrants, fence posts, vehicles, flagpoles, basketball nets, whatever. You're looking on the side of the road. So that's what he said, and that's what other drivers have agreed as well.
The side where John's body was found. And by 6 a.m., John's body was in fact now outside. While this flurry of suspicious activity was going on with the Alberts and the McCabe's, what's happening with Karen? All she knows at this point, think about it, at approximately 2:21, she dropped off John. He walked into 34 Fairview, and that's all she knows. She knows nothing else that was going on. So what was she left to think? He goes in to check the party out, but all of a sudden he's not coming back. He's not responding. Minutes start to pass. 1 minute turns to 2, 2 turn to 10. Where is he? Why isn't he responding? She's sitting in the cold, dark, freezing outside in the car. Naturally, she's perturbed. Being perturbed turns into being peeved. Being peeved eventually turns into being pissed. By 12:30, Karen's mad. She's left 34 Fairview to make a point, but she's still texting and calling. What could she reasonably be thinking at this point? What's going through her mind? 12:33 turns into 12:34. I can't believe he'd do this to me. 12:34 turns into 12:35. Where is he? Why aren't you answering, John? 12:35 turns to 12:36. Jesus Christ. I'm calling and you're not answering. Where are you? Pick up the phone. But there's still no answer. There's still no response. By 12:37, she's getting furious. She does not know that something has happened to John. She does not know that. So she leaves the first angry voicemail. Illustrates frustration, aggravation, all the normal responses anybody might have, you and I might have. But little did she know. The next open voicemail has Karen parking at John's garage after she gets home. You can hear her heels clicking across the garage floor. For all she knows at this point, John's just drunk, he's been partying, he's hanging out, just forgot about her, blowing her off. But John's still not responding, and as the minutes tick by, Karen becomes increasingly upset. Those are the voicemails that you heard. How could he do this? Why is he ignoring me? Why is he ignoring the kids? Those are the thoughts bearing down on Karen Reed as she sat in an empty house late at night by herself. Ladies and gentlemen, she did not know what had happened to John. But within the next voicemail, you quickly learn what she was thinking and what she was feeling. Now it's 5:23 a.m. She's woken up. She's realized that he hasn't come home and he hasn't responded to a single text, not a single call. And anger quickly turns to panic and abject fear. She's so distraught, she reaches out to him again. John, where the fuck are you? She says through tears and desperation. And at 6:03, the question was answered and her worst fears were realized when she finds his body laying, dying in the cold in Brian Albert's front yard. You heard her. You can feel the grief. You can feel the raw anguish. You can see it. You don't have to wonder the emotional journey that Karen traveled that night. You can see it in the video. You can hear it in the audio. From the time he left her and walked into 34 Fairview and she called, she reached out 53 times. She called him 53 times before finding his body. Think about that. The Commonwealth wants you to believe that she murdered this man. And then after that murder, she called him not once, not twice, 53 times. It makes no sense. What does make sense is that she emotionally moved from anger, then to panic, then to grief. So back at 5:07, when she began her search looking for John, she backed out of the garage, and what would happen next would change the entire course of this case. As she backed out of that garage, she hit John's Traverse and cracked her right rear taillight. Folks, the Commonwealth has one job to do in this courtroom. It's an immutable responsibility to provide you with the truth. That's it.
And before we get onto this next section, she called him 53 times. It's a little bit obsessive, a little bit excessive. But all I know is, personally speaking, if I had murdered someone, I wouldn't be calling them 53 times, leaving voicemail and all these other things. And I certainly, when I went out to look for them, wouldn't drive straight to their house. I were straight to the place where the body was, I should say. So yeah, that's not a great thing to do if you did something and don't want to be caught. Yeah, like 52, yeah, 53, no, that's a bit much. So that doesn't. I get that a woman would call a guy 53 times. I get that, but I don't get if you murdered someone and then you call them 53 times.
Not to win the case, but to seek justice and to do it through the truth. Ask yourself, did you get that truth from the Commonwealth? The Commonwealth continually tried to tell you that video showed that the SUV came close to John's Traverse, and it took us showing you the video to unequivocally establish that Karen hit that car and cracked her taillight at 5:07. You can almost hear an audible gasp in the courtroom when we finally showed you the actual video. We could see that tire move. I'm only going to show you one series of exhibits during my entire closing, but it's that important. And it's this. Look at the condition of her taillight when she pulls out of the driveway at 5:07. That taillight, and I'm going to choose my words very carefully here. That taillight is cracked, but it's not completely damaged. And if there was any question in your mind about the level of damage to that taillight at 5:07, all doubt was extinguished.
So, I mean, is there anybody, and how many people do we have here now? We've got 1,744 people here right now. Of these 1,700 of you, is there anyone who looks at these two stills of her car driving away at 5, whatever it was in the morning, and thinks that this section here, this section of the tail light is completely shattered and missing? It looks pretty damn red to me. This is one that I don't know how people can get past. There was, according to the prosecution, this entire red section on the right, like this entire section here and this entire section up here are completely missing. They're completely missing because there's 47 pieces of the tail light allegedly on Brian Albert's front lawn by this point in time. So there should be no red on the right side of these tail lights. I don't know how people get past this. I don't know how people can see this and think that she smashed him in the face and shattered the tail light into 47 pieces. That's it.
When Dighton police officer Barrows walked into this courtroom, he's a sworn officer. He's not associated.
Yeah, and it was the prosecution's witness from Dighton, where Karen Reed's mother lives. They brought him to the stand. He was the one that dropped the big bomb, because everybody else is testifying that it's shattered. It's in 47 pieces on the front lawn. It's completely destroyed. He testified to this, and kudos to Jackson for, in his closing argument here, this is pretty much his one exhibit. This is his one exhibit, and he times it perfectly with his statements here about the Dighton police officer.
To that taillight at 5:07, all doubt was extinguished. When Dighton police officer Barrows walked into this courtroom, he's a sworn officer. He's not associated with Canton. He's not associated with the Alberts. He's not associated with the McCabe's. He doesn't know Michael Proctor. In other words, he doesn't answer to any of these folks. He's an outsider and he's completely independent. And his words were the following, quote, "That taillight was not completely damaged. It was cracked. A piece was missing, but not completely damaged."
Yep.
Take a look at this photograph and tell me, which one looks like Officer Barrows' description? The one on the left or the one on the right?
Yeah, so what we're looking at here is this on the right is what the police, the witnesses, this is what the plaintiff's witnesses, the prosecution's witnesses said was happening. The one here on the right, this is the result of her hitting John O'Keefe at 24 miles an hour with the back of her SUV. All of this red light is missing and laying on Brian Albert's front lawn. Well, they took all of those pieces and they reconstructed it to look over here, to look like it does over here on the left. So they put the puzzle together on the left side picture, and there's this little piece of plastic here missing. These two little pieces of plastic are missing. I wish you could see them better. These two little white spots in the middle of the picture. Those are the pieces of plastic that are missing. And the Dighton officer said it was cracked and there was a small piece missing. This on the left is what the prosecution's own witness that was in charge of keeping the vehicle there until they could bring it back to Canton, this is what he testified to. That matches his testimony exactly. There is no way the police officer in Dighton would look at a taillight like the image on the right and go, it was cracked and there was a piece missing, but it wasn't destroyed. And the good thing about this is this was not the defense's witness. The defense's witness did not testify to it. This was the plaintiff's witness. This was a witness for, I said the plaintiff again. This was the prosecution's witness. This is a witness for the prosecution that said it wasn't completely broken. It was cracked and there was a small piece missing. So you can't blame it on witnesses and defense witnesses being paid and whatnot. So, yeah.
The reconstructed light on the left is what that light looked like before it was in Trooper Proctor's possession. Remember that. That's what it looked like before Trooper Proctor had access to the SUV. And you have an independent police officer telling you so. You'll recall that after John's body was discovered, Lank, very good friend of the Alberts, walked into Brian Albert's house and had an off-the-record meeting with him. No one's ever going to know exactly what that meeting was about, what they discussed, because that interview, like everything else in this case, it wasn't recorded. It wasn't memorialized. But we do know that shortly thereafter, the Canton Police Department was recused from the matter entirely. And the case was assigned to one Michael Proctor. You have to believe that when the Alberts found that out, they thought they hit the lottery. They thought they hit the lottery. What are the chances? The department where my brother works, that would have been great to investigate this case, but that department's been recused. That's tough luck. But the guy who catches the case is Michael Proctor, a guy we go back with for decades. At such a break, they probably thought, when this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud.
Yeah, wasn't that some shit too? And good on him again for bringing this up. Now I love how he's shifted the focus to Proctor, how all of the damaging evidence to Karen Reed passed through Trooper Proctor's hands at some point. For example, he's going to bring up the fact that he had the SUV in his possession. He had 90 minutes before anybody knew he had it. There was only a crack in the taillight with a small piece missing before Trooper Proctor got it. Then eventually there was 47 pieces of it scattered across the front lawn of Brian Albert's home. And in the meantime, he's getting these text messages for these. He's texting all these groups, his colleagues, his friends, his wife, his sister, and he's getting messages like, we should get you a gift when this is over. Ugh. And he's saying, well, no, give it to my wife. For God's sake, don't say stupid shit like that. Don't get anybody any gift. We're just doing our job. I was like, we want to give you a gift when this is over. Okay, give it to my wife. Yeah. Lolly's hitting home. Sorry, God. I apologize, Mr. Jackson. Jackson is hitting home run after home run after home run. Every step. He got off to kind of a slow start, he balked a couple of times, I think, with the reading all of the quotes, but now he is just knocking them out of the park one after the other.
When this is over, we need to get that dude a gift. Oh, wait a minute. They didn't think that. They said it out loud. But still, you've got to imagine that the Alberts had to be stressed. What with that whole thing about a dead body being on their lawn. That might get some attention. And they had to be wondering, will he set up a crime scene? Is he going to come into the house? Is he going to search the house? Is he going to send in a forensics team? Is he going to interview witnesses? Is he going to take us to the station? Will he take our phones? Will he look at our communications? When we look at
We have cat raiders. Hello, people from Cat. Good to see you here, cat people.
our Google searches, when we look at our early morning phone calls, is he going to look in the basement? And Michael Proctor answered every single one of those questions resoundingly. Nope. He's a Boston cop too.
Oof. Oof.
And with that, Michael Proctor didn't draw a thin blue line. He erected a tall blue wall. A wall that you can't scale. A wall that Karen Reed certainly couldn't get over. A wall between us and them. A place you folks are not invited. We protect our own. It's us or it's them. And by the way, who's she after all? Nobody.
She's a
Outsider.
them. Yep.
This
She's
is gonna be easy.
a them.
Or so they thought. Let's look at what Michael Proctor actually did and did not do in this case. One of the consistent issues that's come up throughout this trial is how evidence always seems to be changing and evolving when in Michael Proctor's hands or somebody in his orbit. If it happens once, let's chalk it up to a mistake. Twice, it's starting to look a little bit like incompetence. If that happens every single time, it becomes intentional, which means it becomes corruption. The defense spent some time, we spent some time discussing the tow time that Michael Proctor swore to in affidavits. There was a reason that we believed it was so important, and I want to talk about that for just a quick second.
Yeah, here's where he gets into these timing problems with Proctor and lying on his affidavits about when he took possession of the vehicle. Not good at all for the prosecution. I want to just catch up on a couple of things here. Where are we at here? Cloak and Glomer, almost like court handed out a guilty verdict blueprint. They can stick it on that tall blue wall. That I believe you're talking about the jury form, which I agree is seriously, the one she's using is seriously flawed from the model card that the model instructions that we showed earlier. The model instructions we showed earlier were bad enough, but the one she's using is really bad. And Aussie Wombat, what's up? I'm disgusted and worried now. Well, let's see what the jury does. Have faith in the system, but okay. We talked about that. And great success is how much did Jackson get paid by Karen? I hope a lot. We don't know. We'll probably never know. It's kind of sort of none of our business really, but I hope he got paid a lot because he is doing a phenomenal job. He and Yannetti are worth whatever the hell she's paying. Angela Halo, why are the O'Keefes still siding with these dirtbags? How can you ignore all of this? That is a question I have been asking more and more seriously every day that this trial has gone on. Every day it gets worse and worse. And I don't know how they are still thinking she did this. Why they're not. And I've said this before, the big problem with this, the big problem for the O'Keefes especially, is there's only one option for justice to be served. That is if Karen did it, if she murdered him, and if the jury comes back with a guilty verdict. That's the only way they get justice in this. If she did not do it and they find her guilty, the real killer is still out there somewhere. And they get no justice. They might think they did, but they didn't. If she did it and they find her not guilty, she doesn't get punished. Whether she did it or not, if it comes back in a hung jury, what are you going to do? Retry it in this political climate? There's just no way for justice for the O'Keefes. You'd think they would be a little pissed off at the prosecution, at the way their new buddies, the cops, are handled the investigation. I honestly don't know the answer to your question. I don't know how, and I'm wondering where O'Keefe's dad is. I assume he has to do work and stuff to support everybody and to keep his job, but he hasn't been there, and especially on days like today, where it's a very important day in the search for justice for his son. I wonder if there's not a family rift there. I wonder if some of the family members have said, wait a minute, maybe we need to look at this again. I just don't know. I want this to be over, and I want to hear from people to see, like the family members, to see what they have to say. Well, would you be worried there isn't a verdict yet? No, not particularly. I'm expecting it to come down sometime. My gut feeling was between 1 and 2 hours from now. That's kind of where I had myself set. But it can come down later. But again, as I mentioned at the very beginning of the show, the general rule of thumb is the longer it takes them to reach a verdict, the more likely it is that it's going to be a guilty verdict. But again, that's not any sort of rule. It's just sort of an anecdotal thing. It's just I said a rule of thumb, and then I said it's not a rule, but you know what I mean. It's just kind of a statistical thing. So I wouldn't be worried. They could be taking their job incredibly seriously and having very, very intelligent and in-depth discussions about each and every item on the list. And remember, they have the copy of the jury instructions, and it took the judge an hour to read through the jury instructions. So it could take them a couple of hours to go through it, and then to have all the discussions, several more hours. We're just gonna have to wait and see. Really, that's our only option.
Because this was a concerted effort by Michael Proctor to falsify the time the car was seized, so that no one would know that he actually had possession of the car before the first pieces of taillight were ever discovered at the scene. But he got caught. And when he did, the best he could come up with was it was a typo. Like a dozen times, a typo. You'll remember what that testimony was. The truth is that car was in Michael Proctor's possession from about 4:12 in the afternoon. He said it was 4:16 when he finally had to tell the truth, or some version of the truth. Those first pieces of taillight were not found until after 5:45 p.m. That is the very fact that Michael Proctor was trying to hide by those falsified affidavits, saying he didn't seize the car until 5:30. But that wasn't Michael Proctor's only manipulation of the investigation. What about Brian Loughran? You met him. Michael Proctor did his level best to not just hide evidence, but to hide human beings and from us. Michael Proctor was informed that the plow drivers were out that night. There would be a witness, potentially along 34 Fairview, at the exact times in question. Even Michael Trotta expressly told Michael Proctor that 34 Fairview had in fact been plowed that morning, and by whom. Proctor not only did not interview Brian Loughran, he never disclosed his name in a single report. He hid him. This is a witness who was literally on 34 Fairview at the time in question, where a body was found on the lawn. Wouldn't you want to get the truth from an eyewitness? Wouldn't you want to seek that out? Not if you're Michael Proctor, a close friend of the Alwards. If it were up to Proctor, you literally never would have heard of or from Brian Loughran. That's a scary prospect. I want to touch briefly on the additional physical evidence, or some additional physical evidence presented by the Commonwealth in this case. You'll recall Christina Hanley. She established to a scientific certainty that the glass on the bumper, which was told to you in opening statement, was going to have something to do with this case. The glass on the bumper was going to match that cocktail glass. She told you unequivocally the glass on the bumper did not match the cocktail glass. They came from two different sources. The glass on the bumper has nothing to do with the cocktail glass. So that glass on the bumper had to get there somehow. It didn't get there by being broken from the cocktail glass. See the point? It had to get on the bumper somehow. It didn't jump up there by itself.
See, and that's something that's really bothered me as well. And I'm glad he made a big point of that in his closing argument. They said they kept making a big point that they found glass on the bumper. They found glass near, John O'Keefe's body. But then we find out that they don't match. There was no explanation. They wanted us to believe it all came from the same glass until it was proven that it wasn't, and then there was no explanation from the prosecution how that strange foreign glass got on the back bumper of the vehicle. There was no explanation of that.
And what's really interesting is that there was one piece on the bumper, only one, that matched something else in the case. It was a perfect match to a piece of glass that was supposedly found at the scene. Who do you think had possession of that matching glass? Michael Proctor.
Mm-hmm.
So the glass on the bumper had to be placed there. And the only person who had anything close to matching the pieces that had to be placed there is Michael Proctor. You do the math. That leads us to the magic hair. The Commonwealth spent a lot of time bringing in experts about mitochondrial DNA and maternal DNA lines and comparative analyses, and all that sounds really great and really sciencey, except for the fact that it just doesn't matter. Why? Because you would have to believe that little hair, tiny, tiny little hair, barely perched on the side of that SUV survived nearly 75 miles of a raging blizzard outside.
Yeah, that hair
That would be a magic
BS.
hair indeed. That magic hair means nothing. The DNA.
The magic hair. Yeah, that is some BS that, again, is totally irreconcilable. A tiny little piece of hair, which Lally will tell you in his closing arguments, it was frozen on the side of the car. It wasn't frozen on the side of the car when it got there initially. Let's agree that maybe in some theoretically at least that it would be possible for these hair to freeze to the side of the vehicle. It would take time to do that. And she's driving down the road while this is not frozen on, but it's still hanging on there somehow. This is ridiculous. It's 75 miles in a raging blizzard, and it just sticks there. And weirdly, because he said it was frozen on the side, Lally did, when all the snow melts, when all of the ice melts off the side of the vehicle, it's not frozen on there anymore, and it's still precariously balanced. That is really, really insane. That is some BS. And it wasn't like it was a giant long piece of hair wrapped around something. It was 7/8 of an inch. It was like 2 centimeters for you non-inchers. It was like 7/8 of an inch. It's like that long. And it just, somehow managed to survive 75 miles an hour stuck on the side of a car in a blizzard and melting. And they also somehow found it.
It means nothing. And that's because the hair was from somewhere else. It certainly was not from a motor vehicle incident at 34 Fairview on January 29th. That hair was placed there. The DNA on the outside of the taillight housing also merits very little discussion. John's DNA would be expected to be found all over that SUV, inside, outside, the exterior, the interior, everything he touched would have had his DNA on it. Here's what's actually important about that DNA. No DNA was found on the interior of that taillight. The taillight that they now claim crashed into his arm and shattered. No blood was found anywhere on that taillight or any taillight pieces. And no tissue was found anywhere on that taillight or any taillight pieces. But we're to believe that taillight literally exploded on John's arm at 25 miles an hour with 1,000 pounds of pressure. We talked about the evidence doing very funny things when in Proctor's possession or the possession of somebody in his orbit. Now think about the videos that you saw. How many videos appear to be somehow manipulated or altered? Just about every single one of them. Look at the video of the Sally port. Let's take that one, for example, that grainy one. It's missing the exact time that would show the condition of the taillight when it was pulled in to the Sally Port. Pretty important time, wouldn't you think? Did someone not want you to see what the condition of the taillight was at that exact time? But the good news is there's a second video. It's much clearer. And it's from the same time frame. We didn't get that one for about 2.5 years into the investigation. Literally, it was after the trial started that one was turned over. And this is important. The Commonwealth introduced you to a person by the name of Yuri Buchanan. They presented video showing what was clearly the right side of the car. They asked questions about the right side of the car. You'll recall, Mr. Lally asked Sergeant Buchanan, did you or Trooper Proctor ever go at, or near the right side of that taillight? And while he was asking the question, what appeared to be the right side of the car was looking at you. The video was still up. Buchanan paused, turned earnestly into the microphone, stared at you and said, never. We never went anywhere around that taillight. While he was showing you the right side of the car. And that trick might have worked until we got up to cross-examine him. And only then, on the second day of his testimony, did he have to admit that the video was actually inverted.
And see, I mentioned we would talk about this when we got to this point in the closing arguments. Just personally, what he is going to describe next is infuriating to me. Infuriating. Because he is going to describe how there is no other way that video, there's no possible way that video could have been reversed on accident or as an oversight. Pay attention to what he's saying when he's saying the timestamp wasn't flipped. The timestamp wasn't reversed. Only the video was. So you would have had to go to the extreme steps of taking the video, removing the timestamp, flipping the video, and then putting the timestamp in its proper form back on there. Otherwise, your times would be reversed. So you would have to do that. That doesn't happen by accident. You can't butt edit film like that. You might be able to butt dial your phone, but you're not going to butt dial evidence in video editing. This is infuriating to me. And if I would have seen that as a juror, if they would have shown to me that the police, the prosecution, that they submitted a intentionally reversed video, I wouldn't listen to another thing they say. I couldn't trust a single thing the police or the prosecutor said from that point.
It was backward. And it was cleverly inverted at that. The timestamp had the proper orientation, which means that timestamp had to be removed, the video inverted, and the timestamp placed back on it, which means that was done intentionally. That was not a mistake. And when caught in that obvious fabrication, Buchanan doubled down and said, it's exactly the same. You remember that back and forth. It's exactly the same, he said, as if we're stupid. Is it exactly the same, or is it exactly opposite? Ladies and gentlemen, you were lied to. There's no other way to say it. It's inexcusable. It's abhorrent. But it's also a paradigm of everything that the investigators have been willing to do in this case. Lie, obfuscate, manipulate, alter. And when they're caught, they just excuse it away. Doesn't matter. It's the same thing. What's the big deal? Just look the other way. And don't forget, Buchanan is Proctor's supervisor. And he was in that little group chat where Karen Reed's naked photos were being searched for. You know the saying about the apple falling from the tree. Ladies and gentlemen, we haven't even started talking about the taillight yet. You'll recall that at the very beginning of this case, you were introduced to no fewer than 5 CPD officers very early on who searched the scene. None of them, not a single one, found any taillight material at the scene. 0. Stephen Seraph, Sean Good, Stephen Mulaney, Michael Lang, Paul Gallagher, they were all there. They were all walking right around there. They were all looking. They were searching with their eyes. They were searching with their hands. Some said they were searching with their feet. They even used tools. a leaf blower.
Yeah, leaf blowers. Yeah.
Not one piece of bright red taillight material was at the scene, not a single piece, but incredibly, over the course of the next 3 weeks, according to Michael Proctor, 47 pieces of taillight material would end up being found, some of which were the size of a salad plate. The CERT team shows up later on January 29th, and according to O'Hara, the first few pieces of taillight were found about 5:45. And here's some interesting testimony that you heard. Who else was there? Who did O'Hara say was there? Well, he said his team was there. We certainly expected that, but then he said there were others. These other mysterious figures, some from Canton PD, some from the Massachusetts State Police, that he could not account for. Heavy coats, big masks, hats. Even Lieutenant O'Hara could not tell who was who, but he did note Canton police officers were there who were unaccounted for. Massachusetts state troopers were there unaccounted for. And during that search that was overseen by Trooper Tully, Proctor's supervisor, 3 pieces of taillight material were found. That's super important, and I want to concentrate on that for a second. O'Hara said all 3 pieces were in an area about 12 inches square. That's an area about as big as your dinner plate.
Yeah, this is the Penn and Teller routine here. This is the Penn and Teller magic trick section of the closing arguments. This is what he was talking about when he was talking about 3 pieces of plastic magically turning into 5 pieces of plastic. Again, casting doubt on the honesty, the veracity, hiding things, doing things improper. This is a fun. Fun is a bad word to use. I know. It's an interesting point where they were caught not once but twice with evidence handling problems. Jinx Clemens asks, Legal Vices, what is your take on the fact Judge Bev seems so agitated? Isn't her job to listen to everything and remain neutral? I started out this trial by saying people are being really, really, really hard on the judge. She's not as bad as you think she is. But that changed about 3 weeks ago. that changed where she is overly agitated. She has a different set of rules for the prosecutors and the defense. She clearly doesn't like Yannetti or Mr. Jackson. It's not a good look for Bev. It's not a good look for Judge Bev. She should listen. She takes a lot of things that the defense does personally. It's not a good look. Showbiz quiz with the $5. Could they agree on not guilty but get hung on the lesser charges? Well, it would still be a hung jury. We wouldn't know where they were on the charges. They would say they couldn't agree on the charges. But yeah, you just not coming to any agreement, not being able to unanimously decide whether she's not guilty of everything or whether she's guilty of A, B, or C. Yeah, that would still be a hung jury. And you would start over again if they'd start over again. And ashes are, I'm going to laugh if the jury sends a question to the judge about how to find her not guilty of lesser included. That actually would be funny. Thank you very much for sharing that. And while we're paused here, we've been doing this for 2.5 hours now. Who knows when this is going to end? I'll probably go another hour or so, and then come back if and when there's a judgment. But in the meantime, we've got 1,754 people here, nearly 1,800 people. We've got 1,311 likes. That is amazing. I really, really appreciate that. That is a huge number of likes. The 1,750 of you that are here, you could be anywhere doing anything, watching anybody's channel, not watching a channel. You could quite literally be anywhere doing anything, but you've chosen to spend your time here with me, and I am deeply grateful for that. I don't take your time for granted. And those of you that are sending the super chats and the gifted memberships and things, you parting with your hard-earned money to support my channel, whether it's 99 cents or $500, it's your money that you're parting with, and I don't take any of that for granted either. Bless you all for being here and for being the support. And even if If you're just here chatting, thank you so much. I appreciate it. I appreciate you here keeping each other company. Vice Squad, the Vice Squad chat is the best chat on the entire internet. And I'm glad for all of you that are here now. Thank you so much for that. I just wanted to say that if you're inclined to hit that like button, please do. And if you haven't subscribed and want more of this, we're going to be starting the Alec Baldwin trial about 10 days from now. So there is that coming up. Hit the notifications, hit the subscribe button, and we've currently got 77,234. We're 66 away from 66. Yep, we're 66 away from 77,300. Let's see if we can get up to 77,300 today. If we get 66 more subscribers, that would just be awesome. All right, with that, let's jump back into that. That's enough of me being sappy and me pushing for likes and subscribes. Let's get back to the closing arguments. We did have a couple more super chats come in here, didn't we? I think we did. Let me see. Just double check. We have one. Anton Ivanov. Andrea Burkhart has a thread on this on Twitter. A thread on what? And she has a mysterious thread on Twitter. Let's see what Andrea Burkhart's Twitter thread is about. Andrea, where are you? Andrea is such an awesome person. We love Andrea. Andrea Burkhart. There you are. What does she have a thread on? She has a thread on the verdict form. What does she say? My concern with this verdict slip is if the jury acquits on a greater but hangs on a lesser, there's no way to indicate that. Exactly. Double jeopardy bars retrial on any acquitted offense. Ooh, that's even a better point. If they acquit, Andrea, you're smart. If they acquit on the second degree murder and get hung on the lesser charges, although it would still be a hung jury, jeopardy would attach to the one that they said not guilty of. But there's no way to indicate which one. Ooh, I like that. See, this is what when we eventually get a verdict, one night I'm going to try to get Andrea and maybe Ian and other people that follow this and to kind of have a big panel discussion about our thoughts on what the outcome was and whether we agree with it and the points. So yeah, I'm gonna have to write this one down. This is good. Double jeopardy bars retrial on acquitted offense. What's the harm in giving them a clear option for each charge? Don't understand the ruling at all. Andrea is a smart cookie. All right. Thanks for pointing that out, Anton. Thank you so much. All right, back to it.
Tully, however, claimed that one red piece was found about 3 feet away from that was a shoe. About 1 to 2 feet from that was a clear piece of plastic, and a few feet away from that was a red piece of plastic. So we have red, clear, and red over the span of about, added up, probably 10 or 12 feet. Ladies and gentlemen, both of those things cannot be true. Somebody is taking liberties with the facts. Then Lieutenant Tully comes to court and makes this big grand gesture of opening all these evidence bags. These 2 evidence bags in particular represent exactly what we're talking about. Those 3 pieces, red, clear, red. They're marked, they're sealed, they look official. They're not stop and shop bags, thank God. At least they've moved up from that. They've even got evidence tape on them. Who knew?
And welcome,
There's evidence tape around here.
You're welcome to it.
So this must be real evidence, right? It must be real evidence in this case. And after making that big theatrical display, he opens up the bag with the red pieces and he pulls 2 pieces out. That's okay. Put the 2 red pieces together. Good so far. Then he opens up the second bag under Mr. Lowley's questioning. And you remember he hesitated just a second. Opened that bag and pulled out 1 piece of clear plastic. Then pulled out a second piece of clear plastic with no explanation as to how that could have possibly happened. And he quickly returned all 4 of those back into the bag, sealed them up, and we're done for the day. The next day, I asked about that evidence again. I asked him to open up that bag with the red pieces, and he did the same thing. Pulled out 2 red pieces of plastic. I said, you'll recall this, I said, look deeper, look closer, sir. Pull everything out of that bag. Would he have had I not suggested it? And then he pulled a 3rd piece of red plastic out of the bag. So miraculously, Trooper Tully's 3 pieces of plastic became 5 pieces of plastic. right before your eyes.
The Penn and Teller part of the show.
Ladies and gentlemen, the forces at play that multiplied those pieces of plastic inside those evidence bags are the same forces at play that multiplied the pieces of plastic at 34 Fairview. Think about that. Let that sink in for a second. How easy is it? That's not sloppiness. That's evidence manipulation. That's how over the course of 3 weeks, those pieces of plastic go from 0 to 3 to 5 to 47. Ever increasing in size with every single search. Now, knowing all that, ask yourself the looming question, who had access to that taillight, the cracked taillight? Who was it? Go back and watch the Sally Port video. I'll give you the timestamp, 5:37. And see it for yourself. We know that Trooper Proctor, with binder in hand, walked by himself. Once we corrected the video from being inverted, you can see that he walked back by himself to the right rear taillight where nobody could see what he was doing. Higgins' own key swipes put him in the Sally Port that same afternoon and evening. And then the Sally Port video magically skips and Chief Berkowitz appears right next to Proctor at the back of that vehicle in the same spot, and they walk out of the Sally Port together. Where were they going? Remember O'Hara? Unidentified troopers and Canton cops were at the search at 34 Fairview. How hard is it to drop a piece of plastic?
Not hard
We
at
spent a
all.
long time talking about the compromised and altered and tampered and manipulated evidence. And I want to switch and talk a little bit about the true facts in this case, because you did hear some true evidence and true facts. The Commonwealth presented about 67, maybe more, witnesses and expended 30 plus days of trial and 9 weeks of your life. Maybe we're in the 10th week. For what? It should be relatively simple, right? The Commonwealth claims that Karen Reed pulled up to 34 Fairview, John got out of the car, she reversed into him and hit him, and then she drove home. That's 4 facts. It's just 4 facts. That's all it is. What evidence do they actually have to prove that that SUV ever hit John? The answer is none. They don't have any. There's no evidence whatsoever that Karen Reed's vehicle ever struck John O'Keefe or that Karen Reed ever wanted to strike John O'Keefe. In fact,
And that was a good point to make, because intent is one of the main elements of the main crime that she's been charged with, the second-degree murder charge. Basically, that you have to prove that she intended to kill him, and there's no evidence of that. and again, during the closing arguments that Lally gives, listen for when he says that the time. Listen for the time he gives in his closing arguments as to when she struck John O'Keefe. Very, very telling.
every single piece of material.
Oh, and Rager90 is a new member of the Clean and Sober crew. Thank you so very, very much. I appreciate that. And we're gonna be doing a members only stream here this weekend. We were gonna do it last weekend, but F it Friday got in the way of that.
Evidence in this case unequivocally proves the opposite. John went into that house. That SUV was not damaged by hitting John, and John's injuries did not come from being hit by a car. That's what the evidence actually shows. The Commonwealth knows that, and they've known it for a long time, and Proctor knows that. Because of that, the Commonwealth just resorts to character assassination and talking for weeks on end about the snow. Let's talk about what the real evidence actually shows, the unassailable science. Let's talk about the truth. Concerning John's injuries first, the Commonwealth's own medical examiner, Dr. Scortibello, could not conclude that John was hit by a car. Think about that. And she would not even say that it was a homicide. She told you without any dispute in this case, quote, evidence pointing toward one manner of death is no more compelling than evidence of a competing manner of death, end quote. Her words, not mine. She went on to say it's just as likely that he was punched and fell backward. His injuries are consistent with that. In fact, in her expert opinion, his injuries are consistent with a physical altercation, as she testified, but they are not, in her words, not classical injuries from an auto pedestrian accident. That by itself is reasonable doubt. But the evidence and the truth goes far further. We introduced you to not one, but two thoroughly credentialed medical examiners or medical experts, Dr. Sheridan and Dr. Russell, both of whom said John's arm injury is consistent with an animal attack. Dr. Russell studied, diagnosed, and treated up to 1,000 animal wounds. She's an expert in animal wounds, and she was unequivocal. Those wounds are from an animal, likely a large dog, which means that John was attacked inside the home where Chloe was.
If only we had
There
Chloe
is no other
available.
possibility. And Dr. Sheridan, for his part, with thousands of 13,000 autopsies under his belt, decades of experience as the chief medical examiner, who's triple credentialed in anatomical, forensic, and neuropathology, he told you that John's injuries are inconsistent with a motor vehicle accident or incident. They're consistent, however, with a physical altercation. In layman's terms, the science proves John was beaten. That also is reasonable doubt and should end this case. But the facts and evidence don't stop there. Two of the most highly educated and highly qualified engineers you'll ever meet, Dr. Dan Wolf and Dr. Andrew Rinchler, mechanical engineer and a biomechanist. They reviewed this case. They did testing, they did analysis, they evaluated the case scientifically. They were not hired by the defense, not by the Commonwealth. They're completely 100% independent.
Which I think is a big thing. And he hit it during both of their respective testimonies, and he highlights it here. Those two superstar biomechanic guys, they couldn't mention who paid for them, but he said they weren't paid for by the defense. They weren't paid for by the prosecution. The prosecution could have used these people, but they chose not to. The prosecution could have used their report, but it was completely the opposite of what their theory of the case is. So the defense called them. Those two witnesses, those two superstar biomechanic scientists, they were independently hired and paid for by the FBI. They can't mention that at trial, but they come close a few times. So independent FBI expert is part of the FBI investigation into the Commonwealth's prosecution of Karen Read, which is very, very interesting. So yeah, it's kind of bad when you're being investigated by the FBI. At the same time, you have to try to say the FBI's people suck at their job and aren't qualified.
Of any party in this case. And they were equally available, by the way, to the Commonwealth. They could have called them. They explained that John's injuries were not caused by being hit by Miss Read's SUV, and that the SUV was not damaged by coming in contact with John O'Keefe's body. That should end the inquiry right there. Both sides of the equation. From a physics, engineering, and biomechanical standpoint, they established that John O'Keefe was not struck by Karen Read's vehicle, period. And that is yet another fact that establishes reasonable doubt and should put an end to this case. So instead of calling the ARCA experts, which they had available to them, the Commonwealth chose to introduce you to Trooper Joe Paul. You'll remember his testimony. I think I'm being kind when I say that Trooper Paul's analysis lacked credibility. Trooper Paul lacks the experience, the education, the training, the background, and the knowledge to not only render opinions on these issues, but to even understand the issues themselves. He makes the absurd claim that John was hit on the elbow area of his arm by a taillight. He was spun to the left in a pirouette. His arm stayed on the light long enough for the shards of plastic to explode around him, scratching his arm, even though he was wearing long sleeves, then projecting him 30 feet to the left, but not before making a stop to hit his head on either the curb or the pavement, before coming to his final resting place with his unbroken phone tucked neatly under his body.
Mm-hmm.
It's nonsensical. It borders on laughable. Compare that testimony to Dr. Dan Wolf and Dr. Andrew Rinchler. Both PhDs in engineering, both top of their field in accident reconstruction, both published peer review articles, on the issues. Both men are highly sought after by the likes of national sports leagues and the United States Department of Defense. And these men are unrivaled in accident reconstruction. What did Dr. Rentschler say before he left the stand? This was even under cross-examination. He said that the physics and the science don't lie. His words were, you can't deny the science and the physics. John wasn't hit by that car, period. The Commonwealth cannot explain John O'Keefe's injuries. They can't explain his head wound. How did he get the head wound if he landed on snow-covered grass and dirt? And by the way, before Mr. Lally gets up and says it, because I know he's going to, there is zero evidence before you, zero, that cold grass and dirt turns into ice or turns into concrete. Zero. They can't explain the injury above his right eye, that laceration. They can't explain his nose. They haven't even tried to. They can't explain the injury to his tongue, the laceration on his tongue. They cannot explain the injuries to his back, to the back of his hands, the bruises, and certainly they cannot explain the injuries to his right arm. But maybe most importantly, they cannot and haven't even tried to explain the lack of injuries on John's body from the neck down. Nothing. He was pristine. Not a bump, not a bruise, not a fracture, not a broken bone. Nothing to suggest that he was hit by a 7,000-pound SUV going 25 miles per hour. And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision.
that there was one of my favorite points of the entire closing. Trooper Paul, who is dumber than a bucket of rocks, who, when he was asked about kinematics, said it's the study of forward. And couldn't answer even the simplest questions about his own job, who Jackson had to coach him, had to give him a lesson in what his job entails and what the big words mean. I think you called him one of the best and brightest. That was that's just a personal thing.
And what of that right arm? According to the Commonwealth's best and brightest, Trooper Paul, John absorbed the entirety of the collision, the whole collision, with that 3.5-ton SUV entirely with his right arm, launching him some 30 feet. But amazingly, the arm suffered no break, no fracture, and didn't even get a bruise. So how are those injuries properly?
No bruise on your head, back, arms, neck, legs, chest, hips, when being smashed by a 7,300-pound vehicle, a 7,000-pound vehicle going 24 miles an hour. Not a single bruise. That's a problem.
Explained. The evidence is simple. John got into an altercation. He was punched. He tried to defend himself by putting his hands up. He may have even scratched his own nose by putting his hands in front of his face to defend himself. His hands were bruised and covering up.
5 minutes, Mr. Jackson.
Thank you, Your Honor. As he continued, he got hit, punch went through, and he fell to the ground, fracturing his skull. At some point during that altercation, the dog got a hold of him, and the dog was pulled away. Every single injury is answered. Every single injury is explained by that. Ladies and gentlemen, given what we know about the facts and the physical evidence in this case, the actual truth in this case, how did this happen? How did we end up here? We ended up here because of relationships, insider trading, playing the who you know game, and building a tall blue wall, which takes decades and generations. But the real question is it going to continue? Will this festering malignancy that allows a lead detective and his supervisor to gloat and sneer while looking over naked pictures or looking for naked pictures of the woman that they've targeted, will that continue? And the answer should be, not if you have anything to say about it. Michael Proctor is the lead investigator in this case, and much as the Commonwealth might try, they cannot distance themselves from the stench of him on this case and this investigation.
The stench of
Those secret group
Proctor.
chats illustrate the quality and character of his investigation. Remind yourself how an, quote, unbiased and an objective investigator, someone who's supposed to be looking for facts. Ask yourself, how did he approach his job? Late at night, sitting there in his office, deviously looking for naked pictures of Karen Reed and talking about her like she's a piece of meat. Talking about her bodily functions, her medical conditions, calling her vile names. I don't even have it in me to repeat what he said about her. He reduced her to an object, and he went further by insulting her. He went further than insulting her, and he dehumanized her.
All right, I was going to ignore this, but everybody in chat is mentioning this, that Kathy Russin from Law and Crime says there's a jury question. Everybody, I'm watching the court feed. As soon as the camera moves off the fan, we'll bring it up. I'm watching it. I have it here the entire time. Anything that happens, we catch it. So let's continue here until there's some motion with the camera. And I'll know I have the audio up. So as soon as there's any court audio, we've got it all covered.
He's done betraying that very humanity. He wished for her to commit suicide. That, ladies and gentlemen, is how you frame someone. That's how you dehumanize someone so viciously that you can just pin it on the girl and cover for the homeowner because he's a Boston cop. That's how you rip a person's life apart and sleep like a baby while doing it. And then further that by saying, I hope she kills herself. Ladies and gentlemen, I just began the discussion this afternoon or this morning with a quote about the truth. And I did that because that's what this case is about. Top to bottom, tip to tail. It's about the truth, not hiding it or concealing it, but exposing the truth. The truth is immutable. It's not a feeling. It's not a whim. It's unflinching. It's unchanging, and it's everlasting. That's why the law is steady. That's why it's not captive to the whims of people drunk with power who think they're above the law, who think they're above scrutiny. That's why you stand as the guardian of justice and the protector of justice. The law demands the very integrity that Trooper Proctor and his investigation lacks, and it requires that you cannot convict Karen Reed unless the Commonwealth has met its incredibly high burden to prove every element beyond a reasonable doubt and to a moral certainty. And a moral certainty is defined as the highest degree of certainty possible in matters related to human affairs. It's the highest degree possible in your life. That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best.
All right, we've got camera motion here. All right, let's bring this up real quick. Let's see. Push. All right, we've got this going here. We got to fast forward to where we are and go.
Goes back to session. You may be seated.
Judge, we have a question for the jury. It's been marked QQQ for identification.
So, question, can we request the cert report detailing the search performed? So they can request it, but they can't get it. So I'm just going to say you have all the evidence in this case. We'll figure that out. I'll get some language from you. But Mr. Jackson, after our hearing this morning, I considered what you said. I went back and I read the jury instructions I gave yesterday. So I do appreciate the concern about the confusion this might cause the jury. I think it's easily clarified with the supplemental instruction. I don't think it's the verdict slip. I think it's how they're to follow the verdict slip. So what I've written up, this is a very rough draft. I'll read it to you. I'll take a break and let you consider it if you want. And this works out. I received this, I don't know, 15 minutes ago, and I've been the letter, the question from the jury. So it seems a good time, so I was working on this, it seems a good time to bring them in for an answer to that question. And I would say, as long as I have you here, I want to clarify my instructions regarding your verdict as to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime, which are involuntary manslaughter and motor vehicle homicide, felony, OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor. And if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. The lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proved all 5 elements, or proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser
Just put
included
a not
offense of
guilty box.
involuntary
How
manslaughter.
fucking hard is that?
If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all elements of manslaughter while operating a motor vehicle under the influence of liquor, and has failed to prove all of the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2.
Just put a
May I
not.
have just one?
Yes.
Why make it more confusing? I'm sorry, that's just dumb. And again, it doesn't take away Andrea's point that there's no way of knowing what she was put in.
Yes.
I deeply appreciate the court's additional clarifying language. I would simply ask for one very simple amendment, and that is at the top of the verdict slip, it says the 2 words, not guilty. We would ask that the verdict slip read, not guilty of the offense charged or any lesser included offense. That's it. And I think that's
the model form we read first.
Instruction would satisfy the defense.
Do it, Bev.
Oh, I think I know it will. That's all we ask.
All right.
That's the wording on the model form that Hayden Aussie Overlord sent us earlier that we read first before we read the
So
actual
there are some like minor changes we have to make to the verdict slip anyway. Just, it has to be consistent. So the manslaughter while operating a motor vehicle under the influence, the tab needs to, actually, Tori. So there needs to be some physical changes on the verdict slip. Anyway, it needs to be indented. There needs to be a colon after guilty of offense charged. It's not complete. It doesn't have under the influence of liquor. It just says under the influence. So there are some minor changes that need to be made to the verdict slip. Does the Commonwealth oppose the suggestion made by Mr. Jackson, which seems like a reasonable one?
No, Your Honor.
All right, so it will be not guilty. So tell me again how you want it.
Sure.
It's the same as on the model form.
Of the offense charged or any lesser included offense.
I think the clarifying language that I proposed is important.
I do too, and I appreciate that. I think with that amendment to the slip and the clarifying language, I think coupling those up is exactly what the defense was asking for. I appreciate that.
So I need to clean, I'd like to send in a written copy of what I just read there. I have a couple of things bolded. I need to fix this up a little bit. I mean, it was just done quickly. The jury's been waiting. Why don't we bring them in? And I will tell them that a new verdict slip will come into them. How's that? I do, though, have to make a finding that the verdict slip as is was proper. All right, so we'll just leave it at that. I'll make the amendment that you want, but that's my finding.
Thank you, Your Honor. Just from a logistics standpoint, once the new verdict slip is prepared and ready,
We all need to see it.
I was just going to ask, do we have that emailed to us or something?
Yeah, we all need to see it. I will work with Tori. All right. All right, can we bring the jurors in, please? Oh, I'm sorry. What suggested language on the cert report?
I'm sorry, Judge.
Any suggested
They're
language
like, oh
on your
yeah,
question?
the jury had a
No, I
question.
think the court's correct, that in terms of the cert report request, the court's answer is right on point, which is you are.
I like how they all forgot the jury had a question.
Certainly, you're directed to review the evidence that's in front of you, and that's it.
I'm just going to say you have all the evidence in this case. We will not give you anything. Okay.
Mr. Jackson, gee, got her to change her mind. Now, while the jury's coming in, this is what was being shown. This is the sample form. This is the wording they wanted, which is on the Massachusetts sample jury verdict form. We find the defendant not guilty of the offense charged or any lesser included offense. That's all it says, not guilty. They wanted to say what it says on the model form. Absolutely appropriate, absolutely spot on. Great job for convincing her she was completely wrong and for getting her to change her mind.
All right, so jurors, we're in receipt of your question. Can we request the cert report detailing the search performed? I take this as a request, and the answer is that you folks, you have all the evidence in the case. So what you have is the evidence in the case. You won't be receiving any additional evidence. But as long as I have you here, I want to clarify my instructions regarding your verdict is to count 2 of the indictment. As I instructed you yesterday, there are 2 lesser offenses of that crime,
we get to hear all of
which
this
are
again.
Involuntary manslaughter and motor vehicle homicide, felony OUI, liquor, and negligence. Therefore, count 2 encompasses 3 separate charges, the most serious of which is manslaughter while operating a motor vehicle under the influence of liquor. In considering count 2, you should first focus on the crime of manslaughter while operating a motor vehicle under the influence of liquor, and if the Commonwealth has failed to prove that crime beyond a reasonable doubt, then you are to consider the remaining lesser included offenses in descending order. So, the lead charge is manslaughter while operating a motor vehicle under the influence of liquor. If you find that the Commonwealth has proven all 5 elements of this charge beyond a reasonable doubt, then your verdict shall be guilty of manslaughter while operating a motor vehicle under the influence of liquor. If, however, you find that the Commonwealth has not proven all 5 elements of manslaughter while operating a motor vehicle under the influence of liquor, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 3 elements of the lesser included offense of involuntary manslaughter. If the Commonwealth has proven the 3 elements of involuntary manslaughter, then your verdict shall be guilty on the lesser included offense of involuntary manslaughter. If, however, you find the Commonwealth has failed to prove beyond a reasonable doubt the crime of manslaughter while operating a motor vehicle under the influence of liquor and the lesser included offense of involuntary manslaughter, then you are to consider whether the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, felony, OUI, liquor, and negligence. If the Commonwealth has proven beyond a reasonable doubt the 5 elements of motor vehicle homicide, then your verdict shall be guilty of the lesser included offense of motor vehicle homicide, OUI, liquor, and negligence. If, however, the Commonwealth has failed to prove beyond a reasonable doubt all the elements of manslaughter while operating a motor vehicle under the influence of liquor and has failed to prove all the elements of the lesser included offenses of involuntary manslaughter or motor vehicle homicide, felony, OUI, liquor, and negligence, then your verdict must be not guilty to count 2. So I'm going to send in a new verdict slip on count 2 that's just a little bit different, and we have to sort of change we have to indent something and change the spacing a little bit to make
add
it a little
the
bit clearer
wording,
for you.
add the
Okay, so
wording
we'll
to
get that
one.
into you in the next 10 minutes. All right, thank you all very much.
Go be recess.
New poll for verdict with not guilty added to the top. Yep. That's what we need to do. We need to have a new poll with the not guilty of all charges added to the top. All right. That was our exciting jury question. And then the jury form. They were also excited about the revisions to the jury form. They forgot that the jury had actually asked a question. They finally got around to answering it. All right, we go back to our standby mode here, and wait for the next little bit of drama, which I probably won't be here for. But we're talking about some stuff. We'll see how all of this goes. How long for FBI to raid? We got a few. As long as we're sitting here, let me bring this up. We are right at the very end of Lally's closing arguments. We just backtrack a little bit. Island says, some rando said my star isn't special and called me a whore for paying for it. We all know that makes me want to super chat. Yes. And see, for those of you, we got 1,600 people here. I hate banning people. I hate banning people from chat. I hate it. I hate it. I hate it. I hate it. I can't express the number of ways I hate banning people, because I assume people to be adults and act like adults in chat and to govern themselves. I like when people walk the line. Walking the thin line is fine. We enjoy a good riotous chat. We are a very lively group. We have fun, a little bit snarky. We do some fun stuff, but basically the one rule I have is don't be a dick. And someone was being a dick tonight, and there's no reason to call anyone else in chat a whore and whatnot. And it was going on for a while, and that's the first ban we've had to do in a very long time. Thank you very much, chat. We've got 1,528 individuals here, with many with differing opinions, and I'm just so happy that you guys act normal. Well, I wouldn't say normal because you're part of my chat, but you act like the adults you are. Thank you so very much. So it always stands out when we have to take drastic action like that. Chloe Albert's Revenge with a $5. As a female, I'll just say it. Bev is just too darn old to be PMSing like that. YouTube reviewers, I didn't say that. It was a woman that said that. So I'm just quoting Chloe Albert's Revenge. Jason J with the $2. Thank you so much. But it's just a few bad cops. Myth busted. Well, certainly busted for Canton and parts of Boston. Miriam with the $2. Now I know why it's taking so long to get a verdict. Rolling eyes. And thank you very much to Duncan, Idaho with the $5. Okay, I was only slightly harsh earlier with belligerently incompetent. Bev stepped away and let cooler heads prevail, and that was real big of her. Yeah, it was. She shouldn't have been snippy and snappy and like that in the beginning. She took it personally that her form sucked. But again, cooler heads prevailed. She realized, hey, there's nothing wrong with making it a little more clear. So hopefully this will be a turning point in Bev's life. And in future trials moving forward, she'll realize that Mr. Jackson helped her create a better verdict form. And Xcomer Triple Z, thank you so much. Go to bed already, Jeff, so we can get a verdict in like always. Yeah, see, that's the problem. It always seems like every time I go to sleep is when the cool stuff happens. We've got a few more minutes here. Then we'll talk about what's next here. When Mr. Jackson finishes.
That's the level of certainty. And I'll leave you with this. You have the most powerful tool known to American jurisprudence because you have your vote. No one can take that away from you. Not me, not the Commonwealth, not the court. You may not have asked to be here, but each of you have given something very special of yourselves. You've agreed to do that, which is the highest calling a citizen can answer in any way. You've agreed to give your community your best. And my question to you is, what will you do with this moment? Ignore the lies and the manipulations, the misogyny, the bias, the lack of evidence? Could you ever do that? Would you ever do that? Or will you say with your verdict, I see the truth and I will not ever look the other way? When you stare the truth down, you'll see that the Commonwealth has not proven its case beyond a reasonable doubt into a moral certainty, not even close. Ladies and gentlemen, Karen Reed is innocent. Do justice and find her not guilty. Thank you.
Thank you very much, Mr. Jackson.
All right. I want to say that what we have just witnessed and gone through is a very, very good closing argument. Solid. I would give that a very, very solid A-. I would take a few points off for what we talked about at the beginning. It was a slow start. He was reading things. He was sort of sounding. His cadence was a bit off. He was sounding like he was like open mic slam poetry night for the first little bit. But after the first 5-10 minutes, he finally got into his stride. It started to sound more normal. It started to sound more conversational. It started to sound more pointed and direct than it did at the beginning. So just a few points off for. It wasn't a rocky start. It wasn't a rough start. It just took a while for the oil to get flowing through the machinery. But that was I almost said master class. I almost said it was a master class. While I'm thinking about this, let's bring up the ceiling Dion here. Need to start that. It's just so weird that you can't have two windows open anymore on Edge. But anyway, I mean, two videos going at the same time. And we'll in this just in case something exciting happens while we're sitting here. I guess can we do this? What about this? That's what all right. I guess we don't get one camera and a small thing in the corner. So this is what we're doing. All right. I was going to say master class, but master class is maybe a little too hyperbolic. But it was a very, very good closing argument. It's one that people can look to. It hit all of the elements, the conspiracy theory, that part of the reasonable doubt. It said, even if you don't buy into this, let's look at the science. Don't listen to what the the only people that are giving the evidence, that are saying certain things were said and certain things were found, are the people who are involved. Don't listen to them. Listen to the objective science. And then he went through the objective science. So I think he provided enough argumentation to appeal to the conspiracy theory side of things, and all the cops are in on it, and the other side with, even if you don't think the cops were in on it, the science proves it's impossible to do what the prosecution is saying happened. Lally was not so great. Now we got a few more things rolling in here. Chloe Albert's revenge with a $10. Trooper Paul being crossed on crash reconstruction, and his crayon drawings by an attorney with an apparent engineering background is a real life Wile E. Coyote moment if I've ever seen one. Yep, just drawing the tunnel, just drawing the tunnel there onto the brick wall while Proctor rams his face into it. That was kind of what happened. Alex Kane. What's up, Alex Kane, who's been a member for 3 months. It's always been done this way. Surprised why Norfolk County is this way. Normal for Norfolk. A phrase on this side of the pond obviously made it over to the Pilgrims. Sacco and Vanzetti, same court. Oh, really? This is the Sacco and Vanzetti courtroom? I did not know that. Wow, that's way cool. If you're not familiar with the Sacco and Vanzetti case, just Google it. That's actually really cool. Well, kudos to you for bringing that to my attention. That's way cool. Huh. All right. His big drawings had Acme stamped on them. Then after we heard from... Wait. We've got some court audio. What was that all about? Nope, just someone messing around with court audio. I guess it's someone that's just got a live walkie-talkie. Never mind. All right, so what happened after this was Prosecutor Lally gave his hour-plus closing argument. He went past the 1 minute mark. He went past the 1 hour mark, and he went until Judge Bev literally told him to shut up. Literally told him to stop talking. And then, can I just ask one? I just have one more sentence. And he said, all right, you get one more sentence. All right. They just didn't turn the audio off of the court. I missed a super chat regarding about the jury request. Did I? Was it yours? Ah, I see. Ozzy Wombat. Where are we here? Thank you. Thank you for pointing out Ozzy Wombat. Can you please explain again what the jury wanted? What they wanted was they wanted a copy of the CERT report. That's the report done by the CERT team. The CERT team, they're the search and evidence retrieval people. They're the ones that was it Higgins or Proctor that called them in? I think it was Proctor. Higgins has no authority to call them in. The police called them in to do the search of the crime scene in the afternoon. They're the ones that started right about the time it got dark, and they searched and they found the initial few pieces of tail light. So they wanted their report. The jury wanted the report from the CERT team as to what searches they conducted of the Albert residence, and that was not entered into evidence, so they don't get it. The judge said, you have all the evidence that's been presented in the case. We can't give you more. So that's what that was about. They wanted the report from the I didn't think the state police did a CERT report. I don't know if they did or not. I just know it wasn't entered into evidence. And she's saying you don't get it because it's not in evidence. So that's what it was about. I hope that clarified it. All right. So the next thing that happened was Lally gave his his closing arguments. If this goes into another day, if the jury deliberation continues into tomorrow, we will follow. We'll review Lally's closing arguments. I will not inflict that on you right now. It was not good. I would say about 20 minutes into his 1 hour closing argument, he seemed like he was bored of hearing his own voice. He jumped around on the timeline continuously. You know, he would jump up, he'd be in the afternoon, then he'd be in the morning, then he'd be in the evening, then he'd be on the previous day, then he would go, it was just all over the place. He was mumbling, he wasn't having eye contact with the jurors. He was just flipping through his pages. He was dull. He was dull and soul crushing. I'll have to watch it again before I give him a grade, but it's not going to be a great grade. It's not going to be anywhere near the grade that I gave to Mr. Jackson. It wasn't good. It was really not good. And if you look through some of the Twitter feeds from some of the reporters that are there and some of the observers, they said that during Lally's closing, lots of jurors were not paying attention. Some were yawning. Some looked like they were on the verge of falling asleep. So it seems like it was either late in the afternoon and everybody was tired, which it wasn't because it was still morning. Either people were just bored. It seemed like he like I said, he sounded bored of his own arguments. But, you know, what are you going to do? It is what it is, as they say. And he gave those arguments. All right, here's what I'm going to do. I'm going to end the stream here in just a few minutes because it is 1:18 a.m. here in dark, summery South Korea. But what we do during Jury Watch is I have my designated spotter, which is Flux. She's keeping an eye. House of Flux, one of our great mods. You should go subscribe to everything to her channel and like every video she's ever done. She's my designated spotter. She's one of the few people that actually have my phone number and can call me directly. So if the jury comes back, she will call me, wake me up, and I will come running in here and start a stream, and we will watch the verdict live. But as a failsafe, I encourage people to send me DMs on Twitter. I'm going to leave my phone off of nighttime mode and off of vibrate mode, so it'll make all the dings, bells, and whistles, and that should wake me up. So you're my backup. You're my backup batteries. You're the batteries installed in my plug-in clock. So hopefully we'll get this over with today. If not, we'll come back and do the same thing tomorrow. Coming up this week, depending on when this ends, if this ends today, tomorrow we'll probably I'll try to have some guests on maybe to talk about this. Thursday we will do a retro trial. We've been watching part of a retro trial from Florida from 2015, a witchcraft ritual murder trial, a guy that murdered his two half brothers and his mother. We'll go back to watching that. Friday, I don't know what we'll do Friday. I haven't decided yet. Next Monday, working on something. Next Tuesday, probably won't have a stream for reasons that I'll talk about on Monday. And then we'll be getting ready for the Alec Baldwin trial. And we'll be doing cover to cover, gavel to gavel coverage of the Alec Baldwin trial as soon as that goes. So, all right. On the way out, we have 1,252 people here. If you haven't hit that like button, that would be great because we got 1,500 likes. That is amazing. That is so super cool. Thank you so much for that. Hit that like button. If you haven't subscribed, please do. We're inching our way northward again. Let's see where we are here. We've got 77,250 subscribers. We've picked up about 100 subscribers today. That's way cool. If you haven't subscribed, please. We were only 50 away from 77,300. I hope I wake up and I have 50 more subscribers. Make me happy. Give me happy, sweet dreams. I want to say thank you to all of the mods who are here today, doing the moddy best. Thank you to you people in chat for being the best chat there is, hands down, anywhere on YouTube or the entire internet. Thank you for being respectful of each other, for having your differences of opinion. Well, there doesn't seem to be a real lot of difference of opinion in this case, but those that have the differing opinions, thank you for having them. Thank you for keeping us on our toes, and thank you to all of the super chatters, the gifted memberships, the people who have the purchased memberships, and all the support. Thank you. This is not a pay-per-view thing. Even just sitting here in chat, talking to each other, doing nothing other than having a good time, paying attention to a case, and enjoying your conversations with each other. I appreciate you being here. All right, everybody, that's me. What I want to do is, on the way out, we'll play the song. And I've had a lot of requests for a link to the two songs. We had the song we played in the intro, and the Justice Blues song that I wrote and had AI compose. When the trial is over, I'll add them to my playlist. I'm behind on updating the playlist anyway. I'll add them to the Karen Reed playlist after the trial is over. So on the way out, let me just set this up real quick. We'll play us out with that song, the Justice Blues. There we are. Let me get the link. And let's add it over here. We can remove the fan. Goodbye, fan. It was nice seeing you today, Ceiling Dion. And that's, for those of you that don't know, that's what we have named the ceiling fan. That is Ceiling Dion. We won't be seeing much of her around here anymore, will we? All right, ladies and gentlemen, we'll play you out with the Justice Blues. Have a great night, and we might be seeing you in a little bit. Oh, wait. The poll. Let's do our poll here. We don't have a timestamp on the deliberations yet, but it was 3 hours when we started. It's been three and a half additional hours. So it's been 6.5 hours at this point. They've been deliberating 6.5 hours. 37% of you said it would be 3 to 5 hours. You're wrong. 35% of you said 5 to 7 hours. There's about 30 more minutes. I was in that group, so it looks like we are wrong too. Only 13% of you said 7 to 10 hours. 15% of you said more than 10 hours. So the 28% of you that said more than 7 hours, it looks like you're right. We'll have to see where that comes out to be. So thank you so much for voting on the like and subscribe poll. We're done with that. All right, everybody, we are going to play you out here with removing dog cam, adding this to here, and I want to say this to your face. Have a good night, everybody. Or it's good night, good morning, good afternoon, wherever you are. See y'all tomorrow, or if they reach a verdict, as soon as that happens. Thank you, and goodbye. Goodbye, everybody.
Down in the city, where the shadows grow so tall, there's a woman named Karen, caught up in it all. They say she did wrong, but the truth's hard to find. 'Cause the law's got dirty fingers and justice is blind. Whoa, justice blues in the pale moonlight. When the one sworn to serve you don't do what's right. Whoa, justice blues, it's a cold hard fight. In the dark of the night, where corruption takes flight. They twisted her story, turned the facts all around. Made her out to be guilty on shaky ground. Evidence vanished and the lies start to flow. But the deeper you dig, the darker it grows. Oh, justice blues in the pale moonlight. When the one sworn to serve you don't do what's right. Oh, justice blues, it's a cold hard fight. In the dark of the night, where corruption takes flight. She cries out for fairness, for a glimpse of the truth. But the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit. In this twisted tale, it's the innocent they cheat. Oh, the courtroom whispers and the gavel strikes down, but the air's filled with tension neath that judge's frown. Karen stands there strong with fire in her eyes, for she knows deep inside the real crime's in disguise. Oh, justice blues in the pale moonlight. When the one sworn to serve you don't do what's right. Oh, justice blues, it's a cold hard fight. In the dark of the night, where corruption takes flight. One day the truth will rise like the sun in the sky, and the lies will crumble, no more alibis. But until that day comes, she sings a mournful tune of the justice blues neath the pale haunted moon. Cries out for fairness, for a glimpse of the truth. But the powers that be, they ain't got no proof. The badges and the ties, all woven with deceit. In this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat. In this twisted tale, it's the innocent they cheat.
And I'm not leaving yet because I was informed that I forgot 2 super chats. Thank you so much for reminding me and drawing me back here. Sky is a neighborhood with the 5 pounds. I apologize for missing that the first time around. I was just focused on getting out of here. I apologize. Ocean Lorax, what did you feel was the most damaging piece of evidence for each side? God, the most damaging evidence for the prosecution's case. God, there was so much of it. For me personally, it'd probably be the video of her backing into his car as she was leaving the house and driving away with what seems to be a perfectly intact taillight. And I think the closing effectively dealt with that. Boy, the most damaging piece of evidence for the defense's case. That's a tough one. Maybe, I mean, it would have to be the I did it thing. That doesn't mean that's what she said. That's what was alleged. And, I don't, well, Proctor dealt with it. Not Proctor, God, Lally, same thing. Lally dealt with it effectively because there was no chance for the defense to say anything after he did. But Lally kept saying that was sort of the hallmark of his case. He just kept repeating, I did it. She could have said, I did it. Or there were so many ways it could have been done, but he drove it home. I did it. So I would think that would be the most damaging evidence for the defends his case, and I thought Lally did deal with it effectively during his closing. And Chloe the dog, don't worry, you'll get 500 bark DMs. All right. Yeah, let's not send 500 DMs. A few would be okay. All right, now I have got all of the super chats. I apologize for missing those, for skipping those. You guys are super awesome. Please forgive my failings. I hope you're still here to hear it. Don't see either of you commenting in chat, but I hope you're still here. All right, now I really am gone. So get off my porch. Bye, guys. See you tomorrow or later today, whatever.